Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama. Hi, guys. Hold on.
Well, we can bring in
There's something happening.
Google, however, at this point in time, this does not invoke the court to need to go through a Richardson inquiry. The witnesses that you're referring to, have they been disclosed to the state?
Not by us, Your Honor, because again, we have not had a chance to speak with her.
Do you intend to call these individuals?
If we can confirm the information.
These are not answers. If you're not actually intending to call a witness that has not been previously disclosed, at this point, I do not have to engage in a Richardson hearing on this matter. But as far as witnesses that you may be investigating or you may speculate to have relevant testimony, until you disclose them, until you actually intend to call them, there's really not much I can do with this. If you wish for me to hear from the sheriff, I will. But as far as perfecting a subpoena and speaking to these people who are either not under subpoena or not listed witnesses, there's not very much I can do.
Judge, is the defense position that between 12:30 and when we got to the jail shortly before 5, somebody from the sheriff's office spoke with this officer and convinced her that it was not in her interest to cooperate with the defense. We are asking for the court's assistance because the rules.
To do what exactly?
So that we can at least speak with her to find out if she has anything that's admissible.
The court has jurisdictional authority limits. For someone who is not under a subpoena, I just can't compel them to come here, go there, or do certain things. There is no subpoena for this individual. If they choose not to speak with you, so be it. But please bring in the undersheriff. He can speak to these matters that you've raised.
Thank you, Your Honor.
So this little thing just came out of nowhere. Because just as I hit live, they started talking, but they were on the seal. So I'm not entirely sure what this was about.
Whatever happened after we spoke with the officer yesterday afternoon, even if we had a subpoena ready to serve, they have represented to us that she is not available to be served. Without the court's assistance, we cannot accomplish that.
Well, and this goes to the timeliness of the witness itself and the fact that it's occurring in the middle of the trial. But that part of it, again, these are certain things I cannot assist with. And the sheriff of Google, please raise your right hand, sir. Do you swear or affirm the testimony you're about to give?
I think they're voir direing somebody.
If you can just stand in front of the court.
I think it's the sheriff.
Taking the witness stand. If you can explain to me what occurred with, I believe this is one of the correctional deputies that may or may not have testimony concerning this case. Please explain what happened with them to the best of your knowledge.
To my knowledge, I was approached by Captain Georgia Dent, who had spoken with Deputy Franklin, and Deputy Franklin informed Captain Dent that she had received a phone call from inmate Adelson's attorneys, and they were advising her that they were going to be at the detention facility later that afternoon, which was on yesterday, and they wanted to speak to her. So she was inquiring with Captain Dent if she actually had to speak to them, and she was saying that she didn't know what they wanted to talk to her about. Captain Dent then came to me and gave me that information. I then talked to our general counsel, the agency's general counsel, and we were in agreement that she could speak to them if she so choose voluntarily. If she did not want to speak to them, they would have to have a subpoena to compel her to speak. So after speaking with General Counsel, I spoke back to Captain Dent, and she relayed that information to Deputy Franklin.
Did you or any other person in a position of authority over this guard instruct them not to speak to the defense?
No, sir.
Any examination for under Sheriff Google by the defense or state?
Not from the state, Your Honor.
Good morning, sir.
Good morning.
It is our understanding that Officer Franklin is now on leave and not available to be served.
That's not my knowledge. I have no clue about that.
So she is available to be served?
I would think so. I'm not aware of her being on leave.
Thank you.
Yes, sir.
Sheriff
Interesting.
Google, there's no more inquiry that I will make of you concerning this topic. I appreciate you being here this morning.
Yes, sir. Thank you.
I don't know. Something with a correctional officer there. They want to
Concerning
subpoena.
the other witness,
Don't want to.
who is not the guard, was the defense able to make contact with this individual?
Just a moment, Your Honor. Judge, the information that we provided to Your Honor was purely to put it on the record that we had followed that
It's on the
information.
record.
After discussions amongst Ms. Fulford and I, we had decided that we were not going to pursue that given the status of that individual and the misinformation we believe we were given.
Right, as to the, I believe, second witness, is this person going to be disclosed, or are you going to seek to call them as a part of your case?
No, Your Honor.
As to the guard, if you need to follow up with a subpoena for this individual, and they have chosen not to speak with you, you need to do so with all haste. The jurors at the time of selection were told this would be 3 weeks, that it could possibly go longer, but 3 weeks is what they were told. For today's witnesses, let's go through that before the jurors are brought into the room.
Yes, Judge.
I
Let's.
apologize, I did not have a chance to prepare a list. At least for this morning, our intent is to call Kristen Adamson, Linda Bailey, Sarah Newhouse, and Marisol Descalzo.
For this afternoon,
This afternoon is up in the air, and that's going to require some additional conversations with our client.
during lunch break, that would be your opportunity to have any final conversations concerning whether she will in fact testify. We'll give the jurors a longer lunch break if necessary to accommodate this. Instead of an hour and 15 minutes, it'll be an hour and 30. After that, we are going to have to go on the record concerning is she or is she not testifying.
Yes, sir.
Mm-hmm.
Please bring in the jurors.
All right, you
Your
guys.
Honor, I know
Wow.
that
Sir.
3 of the witnesses are here. Mr. Descalzo's flight does not arrive until a little after
10 o'clock is
Yes, sir.
I don't even know who that person is that you're talking about. They're not even on your little list here. Okay, well, so they may subpoena. They're not going to. They're not going to.
Oh, Ms. Kappelman, I neglected to give you an opportunity to speak. If you actually wanted to be heard, please do so now.
She's like, I'm good. This is stupid. I don't care. Not sure what the court officer might, or corrections officer might have heard, but he said they could send a subpoena, but you can't compel them to say anything, and they're just going to get a runaround with that. So I wouldn't hold your breath. But it does sound like either Donna's taking the stand this afternoon, or the defense might rest this afternoon. Maybe not. I don't know. The judge is not happy about their lack of having it together. I mean,
All rise, you're entering the courtroom.
can't even put together a witness list. Good morning, Savage. Good morning. It's already a spicy morning.
Good morning, members of the jury.
Good morning.
Everyone can be seated. We are going to continue today with the defense's case in chief. Mr. Zellman, you may call your next witness.
Thank you, Your Honor. The defense will call Kristen Adamson.
Kristen Adamson. Who are you? There we go. Okay. So good morning, everybody. I know they finished early yesterday. Oh my goodness. I don't think Judge will be happy if they are like, oh, we need more time today. We're going to try to subpoena this correctional officer or whatever.
Please raise your right hand. Good morning. Do you swear or affirm the testimony you will give today will be the truth? You may take your seat. You may examine when you're ready.
Thank you, Your Honor. Good morning.
Good morning.
Can you please introduce yourself to the jury?
I'm Kristen Adamson.
And Ms. Addison, how are you employed?
I'm a lawyer.
What type of law do you practice?
I practice family law and I have done so for 37 years.
How long have you been practicing?
37 years.
Okay. Are you board certified?
Yes, I am board certified in marriage
Good
and family
morning,
law by
Simi.
the Florida Supreme Court.
What's involved in becoming board certified?
And I've been board certified since 1996. I had to take a test on family law, and I had to pass a peer review by judges and my colleagues in the Florida Bar Family Law section. I have to recertify every 5 years, so I've had to also do that every 5 years. I'm coming up, I think 2026, I will be in my thing again. Well, I'll have to recertify.
Have you received any other accolades or awards throughout your career for your work in family law?
I was heavily involved in the Florida Bar Family Law section on the executive council for a long time. I am a fellow in the American Academy of Matrimonial Lawyers, past president of the Florida chapter, and I am a fellow in the International Academy of Family Law Lawyers as well.
Don't forget to like.
All of those required board certification prior to being allowed to be a fellow, as well as another test nationally and locally, and written tests and oral tests as well.
And how long have you been a member or a fellow of the American Academy of Matrimonial Lawyers?
I have been a fellow since
Matrimonial lawyer.
2020, and I was president in 2012.
How long have you been a fellow in the International Academy of Family Lawyers?
Approximately 5 years.
In your work as a family law attorney, did you have occasion to represent Wendi Adelson?
I did
She's
represent
wearing her
Wendi
light-colored
Adelson in
cardigan.
the end of 2012, I believe it was, 2013, and part of 2014.
Would you call her divorce a bitter custody battle?
I would not. That's not how I would characterize it.
How would you characterize it?
She had a relocation case where she desired to go to Miami. All relocation cases are a little bit more difficult than just regular custody cases because we almost always have to have a court determination on a relocation case because unlike almost all other family law cases, relocation is a win-lose thing. Almost everything else in family law is sort of a split the baby. Relocation is not. So we did have to go to court on that. And that going to court always is a little bit harder, but in general, this was more or less after that a run-of-the-mill kind of parenting issue kind of case.
Is it unusual to seek, in your practice, has it been unusual to seek relocation?
No, not at all. I have two right now.
Now, speaking to Tallahassee, why is it not unusual?
Why is it not unusual?
Yes.
It's not unusual because it depends on why someone is here in Tallahassee. Tallahassee has a lot of students with the university. They may graduate with a degree, have children, expect to be able to move somewhere else after they graduate. One person wants to leave, the other person doesn't want to leave. The two cases I have right now, they're not here in front of this court, so they're actually, one of them settled. But one of them, the mother received a potential job offer in North Carolina. The father lived here. She wanted to move to North Carolina. All of his family was here. Her family was not. She wanted to move somewhere else, so that was one.
Good morning, dope.
And
Boys
another
arriving when
one
there's blondes, huh?
that I have right now is a person wants to move to Pensacola. My client wants to move to Pensacola because her family is there, and the father does not want to because his job is here. So it's almost always about moving to be close to your family when a marriage dissolves. I mean, that even happened with my sister when she divorced in Florida. She moved to Atlanta to be close to my parents. It's a very common thing for people to want to move to be near their parents, no matter how old they are.
Now,
Oh, she is on the stand, dope.
do you have parents who attend client meetings?
I do. And it doesn't seem to matter whether my clients are 20 or 40. I have many cases where a mom or a dad or sister or somebody comes to almost every meeting I have, including mediations, and they're heavily involved in the divorce of their sibling or their child, regardless of age. It's just something, families tend to be enmeshed in their other families' divorces.
Family law's a nightmare. Oof.
I usually let them come to mediation because sometimes it's important to hear how the mediation is going so that they don't try to armchair quarterback it after the mediation.
Understood. Now, you indicated that you typically have to go to court for relocation. How difficult is it to get court approval for relocation?
Well, I always tell my clients in Leon County that even though, according to the statute, there's no presumption that someone should be able to leave or not leave, I do think that there's a presumption against relocation. And I always tell my clients that it's a very hard thing to obtain a relocation. That you have to have kind of special circumstances, and there's a whole laundry list of statutory criteria that you have to meet to try to be able to relocate. And so we sit down and we go through the statutory criteria and determine whether or not you'll be able to do it. Most of the time, I tell them it's a 50-50 shot at best. Sometimes a little bit more, sometimes less.
Did you have that conversation with Wendi Adelson while you were representing her?
I did.
Okay. And did you advise her of that same information?
I did. Basically, I told her that if this is something that was important to her, this was her one shot at it. If you get divorced and then try to relocate afterwards, you're probably not going to win unless something really substantial comes up and changes it. So if she wanted to try to be able to relocate, this was her shot at it at best.
Good morning,
So in
Teresa.
other words, is it
Good morning, babes.
not that it's easy, but is it easier to try to obtain relocation in the initial proceeding or in a modification?
In an initial proceeding.
Now, the standard for a modification, what is that?
Standard for a modification is a substantial change in circumstance. And at the time, that I had Wendy's case, there was also another component which no longer exists. But at the time that I had Wendy's case, you had to prove there was a substantial change in circumstances, that it was in the best interest of the child for a modification, and that it was detrimental to the child not to modify. That detriment part does no longer exist. Now you have to just prove there's been a substantial change in circumstance and that it's in the best interest of the children. But at that point, you would have had to prove that it was detrimental in some way to the children to modify.
Is that why you advised Miss Wendi Adelson, if she wanted to try relocation, she should do it at the front end?
Yes. Proving detriment is hard to describe to clients because they don't understand how substantial that really has to be. It has to be very substantial. Children are failing in school. Children are potentially being neglected or abused, or there's alcohol or drug or mental illness.
Okay. Have you ever been successful in convincing a judge to grant relocation?
I personally have only won one case in 37 years for relocation.
So would you say it's difficult?
I think it's difficult.
Now, even though you've only gotten
It's true.
approval for one with the
It's a nightmare
client,
everywhere, though.
have you been able to successfully negotiate for relocation in other cases?
I have been able to negotiate relocation in other cases, sometimes through help of mental health professionals who will interview the parties and the children and make recommendations. Sometimes we'll have a guardian ad litem appointed to make a recommendation. We'll have a parenting evaluation or something like that that makes a recommendation. And if you have those things behind you, then it does help, because most people don't want to go to a judge if you have a mental health professional that says, oh yeah, relocation would be great. So we have been able to do it in that way. I also have been able to have relocations when you have an older child who really wants to relocate and the other parent doesn't object. Or sometimes you have, like in my sister's case, which I actually shouldn't have, but I did represent my sister. She moved to Atlanta, and then her husband was able to obtain a job in Atlanta and move up there to her former husband. So we negotiated all those things.
And I think you said you explained all of this to Wendi.
I did.
Was she aware that the chances of success were low?
Yes. I mean, I told her that this was her shot. I gave her, I thought she had some good reasons. I would
Only-
never have someone file a relocation
Law
if they
is-
had a shot at it. So I think she did have a shot at it for many reasons. But including the fact that her parents were down there, that Professor Markel had a very flexible job. He had family in South Florida. These were very little children at the time. We did not have the presumption of 50-50 parenting, and she had done most of the parenting. There were lots of reasons I felt like she had a really pretty good shot at it. But I did tell her it's not going to be easy.
Okay. Now, let's talk about family law rules of procedure generally. Do the rules require the exchange of certain materials in dissolution proceedings?
Yes.
And what are those?
We have mandatory disclosure in divorce and modification proceedings, including custody and just regular divorce. And pursuant to the Florida Supreme Court rules and 12.540, we have to file a financial affidavit under oath that the parties and lawyers and their paralegals help them fill out. We also provide a laundry list of documents that keeps getting larger. It's bank statements for 3 years, it's retirement statements, it's deeds, it is credit reports. I mean, it's a very large, voluminous amount of documentation that we have to exchange with the other party, the other counsel.
And when completing the financial affidavits, specifically when you completed Miss Adelson's family law financial affidavit, did you gather records in the process of completing that so you could disclose everything appropriately?
We did. We gathered all those records and we exchanged them. and gave them to opposing counsel. Sometimes what does happen is the other side has all the records. For example, tax returns, we have to exchange tax returns for 3 years. Sometimes the father or the husband might have all the tax returns, the wife might have all the tax returns. So you do rely sometimes for the other side to provide the documents that you should have. But
Now,
that does happen.
Do you have to list all assets on the financial affidavit?
Within reason, you do have to list your substantial assets. Sometimes I have people that want to list minutia assets, de minimis assets. We don't really do that. We try to keep it as global as possible. We don't list everybody's clothing or, but we list all the cars, generally speaking. But financial affidavits are also a work in progress. We can amend them. And that is part of what happens when you go through a dissolution. Sometimes more documents come to light. A lot of times when people are getting divorced, they're not always in their best mind, and they're not always working as well as you'd want them to. So it takes a lot of help to get a lot of these documents sometimes. So we amend financial affidavits. And I always tell them, don't worry, we'll amend before we go to court. If we have more documents that come up or we find out more information or you change jobs, we have to do that.
What about non-marital assets?
We generally list non-marital assets as separate if we have knowledge of them. Non-marital assets can be very clean, where you absolutely know something's non-marital, or they may not be, because what people don't always understand, it's an education process as you're educating your client as they're going through divorce. Simply because it's in your name alone does not mean it's non-marital. So it can be in your name alone and still be marital if you have obtained it during the marriage. However, sometimes it can be both, and we have to separate things out. I know with Wendy's case, that was one of the things that happened, is she had an asset that was potentially marital and non-marital because she owned some of it before the marriage, and then she had some of it, she contributed some of it after the marriage. So it's hard to determine how much initially, and we sometimes have to hire expert witnesses, financial witnesses, to come and help us determine what part of this is non-marital and what part is marital. For example, if you have a retirement account and you've contributed to that retirement account before the marriage, everything you contributed before the marriage is yours. It's not marital. And whatever increase in value due to the market is also non-marital. So if you have $100,000 in a retirement account, you get married, that $100,000 theoretically, except for 2009, that $100,000 continues to grow. So you're entitled to the growth on it too as non-marital. So that's why sometimes it gets very complicated and we can't determine it initially when doing a financial affidavit, but we do try to determine it by the time we get to court at least.
Now, I want to back up a little bit. What happened with Wendi Adelson's relocation?
She did not win her relocation.
Can you tell us what happened at that hearing?
So we had a hearing on the relocation. We put on Wendi Adelson, and she testified about the reasons that she wanted to move. She did have a job offer in Miami. We put on the lawyer from the law firm that had offered her the job. He testified about what the job would be, how much more money she would be making, and the flexible hours, et cetera, et cetera. We put on all of that. And then at the end of our testimony, the judge asked to speak to counsel, which happens a lot. And she took counsel out. It was me and Professor Markel's lawyer. And she told us she understood why Ms. Adelson wanted to move. But she wasn't going to allow it because she didn't think she had met her burden of proving it was in the best interest of the children.
During that hearing, or after the judge made those comments, did Wendi go out in the hallway to speak to her parents?
Well, after she made those comments, I went to both Mr. Duggar and I went to our respective clients. We told our respective clients what the judge had said. And basically, if the judge had already determined this without hearing from Professor Markel, we didn't really have a chance of winning this at all because she'd already heard the best case of our case. So I talked to Wendi about that, and then Wendi's parents were there, and I actually spoke to Wendi and her parents, and then she went and spoke to her parents again, I think, if I can remember. It was a long time ago, but I think she spoke to her parents outside of my presence as well.
Did Wendi ultimately stipulate to the withdrawal or the denial of that petition with prejudice?
So what happened at that point was we went back into court. The judge denied Professor Markel's motion to dismiss because he had filed a motion to dismiss our pleading. She found our pleading to be sufficient, so she entered an order denying his motion to dismiss. She entered an order that we stipulated on the records that we would agree to the denial of the relocation. And then she entered another order where we all stood there and worked through with the judge what the temporary visitation would be for the next summer and the next several months before we got to another agreement.
And at this point in time, I believe it was approximately the third week of June of 2013.
Yes.
And what was Wendi's reaction?
At that point in time, I think she was upset that she wasn't going to. I mean, nobody wants to not win their case. She was upset. She was always calm during all of my meetings with her. She understood. She's a lawyer. She understood what I was telling her in terms of the legal ramifications. I think she was resigned to it. We did speak a few times after that because we had to get geared up for the next round of this. We had already gone to mediation before that, and we had not been able to agree at the mediation on the relocation. So we knew we had to go to another mediation. So I talked to her several times about the next mediation, which would be dealing with all the other parenting issues and the financial issues. So I did talk to her quite a bit after that, and she seemed resigned to it.
Now, although the court denied the petition, would it have been possible for Wendi Adelson to offer Mr. Markel any financial incentive in order to convince him to change his mind?
Well, we hadn't finished the case. We still were going to go to another mediation. It's always possible. I tell everyone that even after an unsuccessful mediation, people settle their cases on the eve of trial all the time in some way or another. They do. And it's always best if you can settle your case and not leave it to a court. You have much more control if you are the decision makers rather than the court.
Is there anything improper or illegal with one party offering a financial incentive to the other party to obtain relocation?
No, and I actually have negotiated that in the past
Now,
and since that time as well.
subsequent to that hearing, did you have another mediation on the dissolution, the distribution of assets, and the parenting time?
We did. And at that mediation, we came very close to settling it, and we were there for quite a long period of time, but we did not settle it at the mediation. I think we settled it within a week after the mediation, where opposing counsel and I exchanged a lot of phone calls, and because we had gotten very, very close at mediation, and we were able to resolve all of it within a week of mediation.
Now,
And before we had a court hearing trial set, I
Right on.
believe, and so we were able to do it before the court trial.
Thank you. Prior to adjourning mediation, did an issue come up concerning a potentially non-marital asset that Miss Adelson had?
It did.
And what asset was that?
It was if I remember correctly, it was the Charles Schwab account that we had listed on the financial affidavit in the marital portion. And then on the non-marital portion, we had listed Charles Schwab non-marital portion to be determined. And we went into mediation in that way, not knowing exactly what was marital and what was not marital.
Now, I know in our pretrial discussions, you indicated, can you typically talk about what happens at mediation?
Mediation is confidential, and that's one of the things I tell my clients is that the mediator can't be called to testify about what happened in mediation, and I can't testify about what happened in mediation, et cetera, et cetera. So the theory behind that is that people will be as open to negotiation without fear that it's going to come back in court and hurt them in some way in front of a judge. You can't talk about the settlement offers that were made. For example, in mediation, if they say, oh, but he offered to pay child support above and beyond child support, and then we don't reach an agreement, you can't come into court and say, but he made this offer. So it keeps everybody moving forward and not worrying about what the offers are.
Is there an exception for disclosing what happens in mediation if you're ordered to do so by the court?
There is, and there's also an exception about what happens in mediation if the marital settlement agreement is asked to be set aside for some purpose like fraud or overreaching or something like that, then the terms of it and the mediation would potentially be able to pierce that veil of confidentiality.
You have those commercials
For
down
our
there too?
purposes, in order to talk about what specifically happened concerning that asset in mediation, do you need the court to order that you disclose that information?
I would certainly like the court to order that. I don't want to fall foul of any mediation rules. I can tell you that my client has waived that confidentiality. The mediator, who was a friend and a lovely person, Joe Boyd, he is not with us anymore. And Professor Markel is not with us anymore. So a lot of people in that mediation are gone. And Ms. Adelson has waived confidentiality.
You can just put Edison with the waiver of confidentiality by your client. I will order you to testify on the subject matters being inquired into. The state may cross-examine as to all.
I find this very interesting. Some of you might not find it,
Very much,
but we don't
Honor.
get to see a lot of family
Ms. Adelson,
law
can you
stuff.
tell
Like,
us
good
that
to know.
Charles
So
Schwab account that you mentioned,
I'm learning things.
how was that addressed at mediation?
So this became sort of a last minute little dust up during the mediation. So what we did was we called the Charles Schwab account representative. And this is not uncommon in mediation. And I had Joe Boyd, who was the mediator, come in and talk to the Charles Schwab account representative. So it wasn't just me talking to the representative and telling the other side what had happened. I wanted the mediator to actually do it and to hear it. And so he talked to the Charles Schwab representative, who outlined in his opinion what the possessory status of that Charles Schwab account was, who owned it when, where it was, how it had been separated into multiple counts apparently, and which ones were marital and non-marital. And then
Rich people
he
problems.
went into the other room. We're not in the same room. We're in Ms. Adelson and I are in one room, and Professor Markel and his lawyer are in another room, and the mediator is going back and forth between the two rooms. So in our room, he listened to the what the Charles Schwab representative said, and then he went into the other room and told them what he had said. And after that mediation, Mr. Duggar and I discussed the fact that it actually happened, and everybody felt comfortable with what was marital and non-marital. And that was when, along with other little things
Learning
about
bells.
parenting and other loose ends being tied up, we were able to actually have a marital settlement agreement. The Charles Schwab account, in all its different permutations, was listed in the marital settlement agreement. And Professor Markel had almost $500,000 worth of non-marital Charles Schwab accounts of his own. So he had
Damn.
non-marital money as well.
So based on what you've discussed, Mr. Markel was aware of the non-marital status of that portion of Wendi Adelson's portion of what she would get.
He was.
And as you said, shortly thereafter, that case settled.
Within a week, I think, ish.
Shortly after the divorce was final, did Wendi invite you to a get her groove back party?
I don't remember when the party was, whether it was a month or 2 or 3, but she did invite me to a party in her new, I think it was an apartment or townhouse. I don't remember what it was exactly, but she invited me to a party. It was called Wendi Gets Her Groove Back. And I had several friends I knew of Wendy's that were there as well. And it was just sort of a Wendy's in a good place. Come celebrate my new life party. Yeah, in Tallahassee.
Throughout the course of your representation, could you tell us the total amount of attorney's fees and costs that you incurred in this case?
I think the total amount of costs and attorney's fees, we did take a couple depositions. We had 2 mediations. One was ordered by the court on that relocation case, and then that was a pretty short mediation. It was only a couple hours. The other one was much longer. I think the total attorney's fees were probably about $30,000.
And costs of?
That includes costs and everything, I think.
Now,
I know that sounds like a lot, but it wasn't that much compared to a lot of litigated cases.
okay. Now, litigated cases have multiple evidentiary hearings.
Correct.
Did this?
No, I don't believe we actually had any evidentiary hearings. The only other hearing that we really did have was post-dissolution.
So aside from the relocation, prior to the divorce being final, there were no contested hearings.
There were no contested hearings.
Now, did the marital settlement agreement require that Mr. Markel pay Wendi and yourself certain sums?
So according to the marital settlement agreement, Professor Markel kept the house. So he was supposed to pay Wendi for her part of the house. And all the other assets were divided equally so that he kept an equal amount, she kept an equal amount. He was supposed to pay, I think it was about $120,000 for his part of the house within 60 days. He had the money because he had more than $500,000 in non-marital assets, and he had also
These people
marital
just make
assets
me
as
feel
well.
like a broke bitch.
He was supposed to pay me $10,000 in attorney's fees because he made a lot more money than Wendi did. And it's based upon, attorney's fees is based upon who has more resources, and he had considerably more resources than Wendi did. So that was part of the agreement. He was supposed to pay me $10,000. He was supposed to pay her $120,000, all within 60 days of the agreement, which was July, sometime 2013.
July 31st.
I think that's right.
Did Mr. Markel pay the sums that he was obligated to pay under the settlement agreement?
He was supposed to transfer, if I remember, from one of his Charles Schwab accounts to Wendi, the money. He gave her $50,000 of the $120 in a pretty timely basis, and then he just didn't pay the rest. And I don't like to file enforcement hearings on things like that because it takes a long time to get to court. It's not fun. It's just kind of, so I was pretty much once a week or once every other week asking opposing counsel if Professor Markel was going to pay.
Did he pay?
He did not.
What did Wendi ask you to do to enforce that?
At some point, I wrote a letter, I believe, to opposing counsel. So this was, first it's a bunch of emails and phone calls, and then it's a letter saying, please pay, so we don't have to file an enforcement. A part of our marital settlement agreement, if we have to file an enforcement and we win, which we would have because he had to pay, then he would also have to pay additional attorney's fees for doing that. So then it just
Hello,
becomes more and more money that
Scott.
he owes and he's not paying theoretically.
You're well.
So, and this was all on property issues. So unlike custody, we're not going to be able to, or child support, we can't put him in court or in jail. We're not going to be able to put him in jail or anything like that. We're only going to have to be able to go after his assets and things of that nature. It's a lot easier. People will just pay. So I finally filed a motion for enforcement saying he'd only paid $50,000. He owed the other money, and he owed me money, and I asked for a court hearing on all of that.
Sounds like it was pretty straightforward motion that you filed.
It was pretty straightforward. It was probably 4 or 5 paragraphs.
I'm not
Did
that hip
that
either.
prompt Mr. Markel to pay?
No, it did not.
What happened?
So then Mr. Markel hired a new lawyer. And his new lawyer filed a responsive pleading to my motion, basically saying that he shouldn't have to pay because Ms. Adelson had breached the marital settlement agreement.
How did he allege that she breached the settlement agreement?
He filed multiple motions, but this
This is
responsive
Wendy's
motion,
divorce
the
attorney,
first
yes.
one, basically, if I remember correctly, was all about the money. And he said that he shouldn't have to pay because she had hidden the Charles Schwab money from him, and he used to have power of attorney, so he knew that she hid the money, which doesn't make sense because if he had power of attorney, he would know what the money was. So it didn't make sense to me. But anyway, that she had hidden that money and that she hadn't told him about several other of her retirement accounts, and therefore the marital settlement agreement was breached and he shouldn't have to pay her the money.
Hello, Liz. Good afternoon.
So you filed a
to you.
response, but did he seek to have the settlement agreement itself voided or set aside?
He did not. So, and that is what I told Wendi at the time, is that is not a proper defense for not paying the money. Professor Markel, it was pretty obvious that he had actually written this pleading himself, and the lawyer just signed off on it. It had footnotes, which is not something litigation lawyers would do. It was voluminous, and it was very personal about what was going on and Wendi and how I don't think at this point he alleged that he might have alleged that she had committed fraud. But an appropriate pleading would have been for him to file a 12.540. I know it's kind of technical, but basically, if you think that an agreement is reached and it is not in good faith, or there's assets that were not provided, then you must file within a year for a 12.540 to have the whole agreement set aside. You can't just say one good breach is another. And I filed a pleading basically saying that his motion should be dismissed because it was inappropriate. And
You filed a motion to strike as a sham pleading?
I did. I filed a motion saying this was an inappropriate pleading and it should be dismissed because it wasn't the correct way to go about doing what he wanted to do. And so I then tried to set hearings on those motions so that we could move this forward and everybody could get paid.
In the process of doing this with his responses, did he file subsequently a pleading that further alleged fraud on Wendy's part?
I think he filed at least 1 or 2 more pleadings that did that.
And before we get to the final one, that you advised Miss Adelson along the way of what you just told us about the unlikelihood of his success.
I did not think he was going to be successful in his response because it was an inappropriate pleading and it should have been dismissed, which I believe it would have been dismissed. And you can't say, I'm not going to pay you because you breached this agreement by not giving me documents. That just, first of all, there's a lot of case law that says that if a case is heavily involved with mediations and lawyers, and all these documents have been produced, you had your shot at it. So he was not going to be able to do that. Plus, I knew that he knew about these assets because we had that conversation at mediation, and I had several conversations with his lawyer afterwards, and the marital settlement agreement listed all these assets that he was claiming he had no knowledge of, and they were already listed on the marital settlement agreement. So it was not, in my opinion, a successful response, and I told Wendi that it wasn't, and not to worry about it.
Now, there was a hearing in February of 2014. I think the records indicate that that Mr. Markel and his attorney were attempting to depose Ms. Adelson.
So what happened was, I wanted to take his deposition so I could find out why he wasn't paying. And their response was to want to take her deposition, which I did not believe was appropriate because we were simply trying to enforce a marital settlement agreement, and there's nothing that would happen in terms of that marital settlement agreement that would require him to ask her any questions. So I did file a motion to protective order so that he would not take her deposition. We went to court on that issue in front of the same judge.
And what happened at that hearing?
At that hearing, which we did not have transcribed, which we usually do, but we didn't because it was pretty much a 15-minute hearing. The judge read all of the pleadings, and she said that she was very unhappy with Professor Markel's pleadings. She did not like them. She thought they were a poke in my client's eye, and they were not appropriate, and she never wanted to see pleadings like this in front of her again, but she was going to allow the deposition.
With some limits?
With limits, yes.
Okay.
I don't remember exactly all the limits, but they could only be about certain things.
Now, subsequent to that, did Mr. Markel file
Good morning on top.
an additional pleading
Good morning to you.
concerning complaints that he had about right of first refusal, parenting time, and things of that nature?
So that's the first time.
I think
This
maybe to
is
show
this
that,
is
like,
actually almost a year after the divorce, and we're done with the whole divorce. That's the first time that he brought up any parenting issues.
oh, thank you for the super sticker.
And
Good
it was
morning
a
on top.
series of issues
Thank
that he had
you
now
for that.
about the parenting, and
Appreciate you.
that was that Wendi wasn't allowing him to FaceTime with his children as much as he wanted to. That he wasn't that they weren't allowed to go to be present at the same birthday parties. That if there was a birthday party that he was at, she wouldn't come. Things like that. And that that she wasn't. I think there was a right of first refusal in it, and that she was letting her mom watch the kids, and he didn't like her mom watching the kids. And I think he alleged that her mom was saying bad things to the kids, potentially about him. I think that was the first time. He also, I think it was that pleading where he went on a little bit more about Wendi and how she should probably be disbarred from the practice of law, and that I should be disbarred from the practice of law. I think it was that one.
As he's filing these things, are you still trying to set a hearing or set the depositions and set hearing on your enforcement motion?
I've still been trying to do that. There were a number of hearings that got canceled. Some of them I think were because of the court needed to move things. Some of them were because I was trying to work this out. Still, I'm always trying to work out a case and not go to court if I can. So we were trying to work it out, but he wasn't paying, and I was trying to set hearings on all of this so we could get the money and we could get his motions dismissed because they were frivolous.
Okay. Now, the one motion concerning his my client, Mrs. Adelson, he referenced parental alienation. Have you dealt with parental alienation in your practice before?
I have.
I don't
What is
think
that?
Well, it's not actually a recognized legal term, and it's not actually a recognized mental health term by the mental health professionals.
I think she's just
But
there
it
to
does
be like,
happen.
listen,
We all
like,
know that there are parents who
this
do
isn't the reason why things
alienate
happen. Like,
their children against their
here's the truth
spouse by
of the
saying
divorce
really
thing.
terrible things, or
To help no, but
trying to put up roadblocks to
good morning.
parentings. And I've had cases that were pretty serious in the
Good
past
morning, Dave.
where little children, it doesn't usually impact teenagers. By the time they're teenagers, they've already done they want to do their teenage thing. It really truly impacts not children this young either. It's usually like 7 to 9-year-olds that we deal with when we have parental alienation, where they've completely aligned with one parent inappropriately, and not because the other parent is doing something like abusing them or something like that. It's because the other parent truly is putting up these roadblocks. They do use
And it's
those terms.
gross.
I've seen it.
The statements that were included in the March 26, 2014 pleading filed by Mr. Markel that were attributed to my client, would that have resulted in any sort of relief preventing my client from having any sort of unsupervised time with the grandchildren?
No, it's not possible. And I told Wendi that.
Now, as Professor Markel continued filing things, did you realize that you were going to have to become a witness?
So I can't remember how many pleadings he filed on that regard. It may have been 3. And it was the last one that he filed. I believe it was in May, I believe, where he said that, where he became very personal to me, which occasionally happens. It doesn't usually happen with professional people, so I was surprised. But he became very personal towards me and said that I had committed fraud and that I should be disbarred based upon what had happened. At that point in time, I knew that I was going to actually have to be a witness now in this case. And as a witness, you can't be a witness and a lawyer representing your client. So I knew that I had to withdraw. So I withdrew so that I could testify in the case that was going to come up. And I sought a new counsel for Ms. Adelson at that point.
Did that result in the hearing that had, now, let me back up. Had you been able, prior to withdrawing, to schedule the hearing on your enforcement motion as well as Mr. Markel's motions?
I had it scheduled. It was scheduled, but then I had to withdraw because he filed that pleading after it was scheduled. So I had to withdraw, and I called Jimmy Jenkins and asked him if he could please represent Ms. Adelson. He said yes, but he needed more time to get up to speed on that case, so the hearing had to be moved.
Okay. And around this time, were you aware that Mr. Markel had to change counsel again as well?
I did not know that.
Okay. Were you aware that as Mr. Markel is filing these pleadings, including the one in March, that he continued to ask my client to watch the children during his time sharing?
I don't know what they were. I don't know anything about their correspondence. I really only dealt with Wendi.
And on that note, we discussed earlier that it's not unusual for parents or family to be involved in meetings. Was my client, Donna Adelson, involved in any of the meetings that you had with Wendi Adelson during her initial dissolution proceeding or any of the enforcement proceedings after the fact?
She was not involved in any. I never spoke to her except for the one hearing on relocation that she and her husband came to. But even then, it was very brief. They were very nice, lovely people. I didn't, even after even afterwards, they were fine. I had no issues with them, but I never spoke to them. I never emailed with them. They never came to any meetings. They were not involved with me.
And do you have a recollection of whether my client and her husband were in the courtroom for the relocation hearing, or were they out in the hallway?
I believe they were in the hallway. I don't believe they came in.
Just a moment, Your Honor. Nothing further this time?
Cross-examination.
Morning.
Good morning.
So you said you weren't aware of Donna Adelson's
It's a fun
involvement.
game.
in
She
the-
was not involved with me.
Okay.
So no.
Did you know that she was drafting Wendy's filings and having Wendy copy and paste them to send to you?
She couldn't have drafted any of the filings because I drafted the filings.
What she would like to be put in the filings? How about that?
I'm not aware of any of that, no.
Okay. Do you know that she was drafting things for Wendy to put in her filings in Wendy's voice?
Not that I'm aware of.
Okay. Did Wendy, though, give you input on things maybe to put in filings or things that she would like said on her behalf?
Not a lot. I talked to Wendi on a pretty regular basis when I was filing something on the phone or by email. And she was a very good client, in all honesty, where she listened to me and she basically, we have clients that don't. Now we have clients that give you ChatGPT and want you to do ChatGPT, so there's that.
Oh, that'd
She
be
wasn't
so
that
annoying.
client. She would say something like, well, and my pleadings were very short. I mean, my pleadings were very, very short. They were to the point and like, no, dismiss this. That's not true. There wasn't a lot more going on in most of them.
So you wouldn't have knowledge of Wendy sending pleadings to her mom and saying, let's edit this.
It's true.
No,
It's the only
because I
reason
never
why.
did it based on that anyway.
Okay.
I mean, maybe they did, but I didn't do it.
All right.
And I never heard about it.
Okay. So this would have been between Donna and Wendy.
If that happened, yeah.
You mentioned that, of course, she had a shot with relocation, but given the situation in this case being that the kids were raised in Tallahassee, the parents' jobs with FSU, you were not personally surprised when the relocation was denied.
I'm never surprised when a relocation is denied.
Because it's hard to prove detriment at that time.
I'm always hopeful,
Right.
And I thought she had a good shot or I wouldn't have let her do it. I mean, I'm not going to file a frivolous motion, and I thought she had a good shot for a number of reasons.
Regardless, though, of what you think, do you ever have clients or family members of clients who have unrealistic
Yeah, plain visible
expectations
snacks.
of what the courts will allow or what you can do for them?
Yes,
Okay, even given your best guidance.
yes.
Okay, that's not an uncommon thing.
No, that's why parents are often involved in these cases and come to talk to me about what they think I should be doing. Yes, I get that a lot.
Right, and at that relocation hearing, were Donna and Harvey Adelson possible witnesses?
I've been trying to think about that. I think that that's probably why I had them sit outside, is because they
Right.
could potentially be witnesses in invoking the rule. However, I think we had come to either the close of our case.
But you wouldn't know that until
Right.
you were done calling witnesses.
Correct. So
and-
that's right. Yeah.
Okay, so that's why they were in the hallway.
That's
most
why they're in the
likely.
I send you
Okay,
beef
not 'cause they
jerky.
didn't care,
Internet
they
beef
weren't
jerky,
involved.
Dave.
Oh no, they were very nice. I mean, I met them. They were there when I got there
I
in
hope
the
you like
morning.
it.
They introduced themselves. They were very nice. We did our thing. Came back and told them afterwards. Nobody yelled or screamed or cried or did any carrying on, which sometimes happens. So no, it was all very appropriate.
Okay. Do you sometimes have clients or family members of clients who take the news harder than you do when they lose something in court?
I don't like to lose either. So there's that. I don't like it. That's why I don't like to go to court if I think I'm going to lose. That's why I want to settle things. But sometimes they take it really hard, especially family if they're not there. They do.
Okay. And you said Wendy was upset when she was denied the relocation, but she was calm. Oh, let me also ask you this. Wendy Adelson stipulated to the denial of the relocation after you found out behind the scenes from the judge that it was going to be denied.
Correct.
Okay. And she was upset about it, but calm.
Yes.
She's not screaming.
No.
No. Okay.
And I have people do that. I mean, I've had to have my own clients taken by the bailiff out.
I'm sure
court.
you've seen it all. And how did Donna Adelson feel about not winning the relocation?
I don't know how she felt. I can only tell you that I came out, I talked to Wendi, and then briefly, as far as I remember, because I mean, it was 13 years ago, I think I talked to all of them and kind of told them what happened and what was going on. And, I didn't agree with the judge, but this is the judge and they get to make the decisions. And I think that Wendi went and talked to her parents without me and then came back and said, okay, we're good. We can go into court and we can stipulate,
Okay.
which is what I had suggested.
So if there are emails of Donna Adelson being upset about and very disappointed and about it being denied or unhappy with your representation for some reason, that's not something she's telling you to your face.
I love
No.
macadamia nuts, Simone.
You talked about Dan Markel not paying what he was supposed to pay according to the settlement agreement. In Dan Markel's court filings, did he give, and I know you don't agree with those reasons, but did he give his reasons for not paying?
He gave his reasons.
Okay.
Yes.
And that included the fact of that he was accusing Wendi of noncompliance.
That's true.
Okay. Eventually, did you seek to have Dan Markel held in contempt of court?
I did. It was part of my motion was to have him held in contempt of court and enforce it. That's not the kind of contempt where I can throw him in jail.
Yeah, what does that mean, contempt of court? Can you explain that?
So in a child support hearing or an alimony support hearing, if someone doesn't pay their child support or their alimony, we can have someone held in contempt of court and put in jail if we can prove they had the ability to pay, but they're just not paying. And then the court can put them in jail until they pay the amount they're supposed to pay, okay, because they have it. If it's a property issue, we can't really have them held in contempt of court because it's a property issue. And that was part of why Dan's pleadings didn't make a lot of sense because he was mixing up property and child issues, and you can't do that. It's strictly property or it's kid issues. In a property issue, it would be a multi-step thing to have him held in contempt of court. He would basically, the judge would have to find that he was not paying, he's willfully not paying. And then,
could I ask you a different question?
Okay.
I'm sorry.
but even in a property situation, the court could put him in jail ultimately, but it would be multiple steps I would have to go through. It wouldn't be just one step. It would be difficult.
You guys are
What ultimately is the
ancient.
consequence of that is my question.
So ultimately, the ultimate consequences, we would probably get a final judgment against him for the amount that was owed.
Like a lien.
And a lien against, and we would get a lien against the house, and and I have to do this often, I would send them to a debt collector attorney who would then have to file another suit to be able to collect that money, and then they would probably be able to go into his assets and get the assets. So it's a multiple stage process.
Ugh.
Which is why I just wanted him to pay the money and not make me do this.
So if it was successful, probably a lien. Worst case scenario, he could go to jail. And then him being an attorney, though, could he lose his bar license possibly if he's held in contempt of court?
Yes.
Or at least be in trouble with
Sponsored
the law?
by.
He could. I've had lawyers held in contempt of court over these issues before. I haven't had one lose their license yet,
Okay.
but they could. It is a possibility.
Did you inform Wendi Adelson that you were seeking to have him held in contempt?
Yeah, I'm pretty sure I probably did because it's kind of a generalized form. It's a motion for contempt and enforcement.
Okay. And then at some point, did he allege that Wendi Adelson should be held in contempt?
I don't know if contempt. I can't remember if he actually said she should be held in contempt. Legally, the way that I was using it, I think his pleadings were much more, Wendi should be disbarred.
Okay.
I mean, that's what he specifically said.
Right.
That she was committing fraud and she should be disbarred.
Would you describe this divorce as contentious?
I wouldn't describe the divorce as particularly contentious at all compared to most of the divorces I had. I mean, we settled it. I don't settle a lot of my cases where we actually go to week-long trials over things of that nature. I think it was like any divorce where there were ups and downs of moments where it was contentious and not fun. But for the most part, we kind of settled it. We settled it after mediation and it wasn't a problem. I do think that this whole issue of the enforcement got a little contentious. I really didn't understand it because he paid the first 50,000 fine. And then all of a sudden he decided not to pay the rest. And I didn't really get it and know why he was doing that, because the parenting stuff didn't come up for like several months afterwards. So none of what he was doing made sense. I think he just got upset with Wendi or something. I don't know what it was.
Okay, thank you for that information. It wasn't contentious, but you did say that his motions were very personal. His pleadings were very personal.
That's where I think it became contentious, is
And
when he did that.
Was that personal attacks on both Wendi Adelson and you?
Correct.
And he was alleging that Wendi Adelson committed fraud, right?
Yes,
He's alleging you committed
I
fraud.
did.
It got so bad that you had to get off the case so that you could be a witness on Wendi Adelson's behalf, right?
Correct.
Oof,
That's happened
contentious
before, though.
indeed.
I've had that happen before.
And he alleged Wendi should be disbarred, you said.
Correct.
And he's having issues with Wendy's mom, Donna Adelson, even being able to watch the kids, is what you said in one pleading.
One of the pleadings said something about the right of first refusal that he had, and she shouldn't be allowed to have the kids unsupervised, I think, during right of first refusal, because she was saying things about him to the kids, he thought.
And did the litigation between Dan Markel and Wendi Adelson continue even after you got off the case?
Once I got off the case, it was the end of June, and I think that he was gone within a few weeks after that.
So you were supposed to be a witness on Wendi Adelson's behalf, right?
Correct.
Were you ever able to have that hearing?
No,
Why not?
because I got a call from Jimmy Jenkins when I was in Tampa at something that he was dead.
Hmm.
It's pretty shocking.
Does that happen very often in your divorces?
That does not, we've had a few people get murdered,
Mm-hmm.
and a few suicides,
Yep, it's gross.
but it's rare, and I remember all of them.
I don't know if it's as rare
But not
as
contentious.
people like to make it out to be.
Sometimes,
dangerous
I don't know
time.
with the suicides, I don't know.
That's all.
Thank you.
Redirect examination.
Briefly, Your Honor.
I mean, I don't think she was like super helpful about anything, but I'm nosy. So I enjoyed listening to what she had to say. But yeah, I mean, people literally kill each other over custody, divorce, child support, all of the time. It is a very dangerous, it's probably like the most dangerous, like, court thing that there is. I mean, I hear stories all the time of people killing the other parent over custody and shit. It's crazy.
States the
Very
next
scary.
day, I think it's Exhibit 1, page 441 of the demonstrative. And then I'm holding 454. If you hold that,
Sure.
please.
Okay.
Is that
I mean, that Travis Decker
that
guy.
the March 26, 2014 pleading that Mr. Markel filed?
It appears to be.
Can you turn to 454 that I had tabbed?
Yes.
Is that the prayer for relief for that motion?
Yes.
Can you direct your attention to the portion that reflects my client's, Donna Adelson's time with the children? Does that reflect that Mr. Markel was asking that my client's unsupervised time with the children not interfere with his right of first refusal?
I think you're talking about paragraph 6, where it says, enjoin the former wife from allowing the maternal grandmother to have unsupervised time with the children consistent with the right of first refusal. That was that right of first refusal.
Yes.
And to impose appropriate limitations to safeguard the children from being subjected to disparaging comments about their father.
Ugh, I could never work in family law. What a nightmare.
Adelson, did you testified that the divorce was not contentious, but some of his pleadings post-divorce were contentious,
I think that's accurate.
and that his pleadings were personal? He essentially he attacked both Wendi Adelson and yourself.
Correct.
Is that what caused you to withdraw?
I'm very used to personal attacks. I've had a lot of personal attacks. The only reason, and I'm fine with that, the only reason that I withdrew is because I was going to be a witness, not because I cared what he said about me.
Had Mr. Markel not
It's true. You got to have thick skin for
included
family
in
law.
his pleadings these attacks, would that hearing have gone forward in May of 2014?
If he had not included personal attacks against me that I would have had to testify about, then I would have continued with the hearing.
Now, after I want to go back to relocation. After the relocation hearing, my client Donna Adelson appeared to accept the court's ruling. To you,
As far as I know,
you don't know what she said privately, do you?
I do not.
Concerning Wendi Adelson's involvement in drafting of pleadings, I understood your testimony on cross to be that you'll take input from clients, but ultimately you're the one who is drafting the pleadings.
I take responsibility for my pleadings, and I've never filed a pleading based upon what a client told me I have to do. I will take input because I don't know all the facts. Sometimes I need more facts from them so that I can do it, but I'm ultimately responsible. My name's on those pleadings.
And so you're not going to cut and paste from what a client sends you.
Well, sometimes if they send me really good facts, I'll sort of go, oh, these are good facts. And then I'll take the facts and I'll put them in, but not legal arguments or anything like that, no.
So if you took facts that were provided to you by Wendi Adelson and put those in the factual statements or arguments concerning pleadings or memoranda, the law is still your own writing.
The law is, and I don't really think Wendi, I don't remember that Wendi had much input into any of it, honestly. She wasn't that client. I have clients that are those clients, and she was not that client. I get a lot of chat GPT now, a lot,
Oh,
telling me what I should be filing.
yikes.
I don't think you're the only one there, ma'am. Had
Fucking ChatGPT. I love it, but also
you
people
not
are
withdrawn to be
too
a witness,
reliant on it. It's
the motion would have been
crazy.
heard in May of 2014.
May or June, whenever it was set. I don't remember exactly when it was set.
Okay.
Whatever the docket says for whenever it was set, yeah.
So if the docket reflects, I think it was May 15th of 2014, the hearing would have gone forward.
Correct.
The judge would have been able to make a decision on all the pending issues.
I believe that's the case.
Nothing further.
Will this witness be recalled?
Just a moment. We'll retain her, but she's free to go about her business.
Thank you.
You may step down.
I mean, if Wendi does get arrested, that'd be a pretty good witness for
Please call your
her,
next witness.
actually. I don't think she really did much for Donna,
The
but
next witness is Linda Bailey. She could be quite lengthy. I don't know if your client wants to take a brief break. Jurors need one.
Do any of you need to take a break or use the restroom? Please raise your hand.
you can wait, Zoe.
A very equivocal wave, but I'll take it. The bailiff will take you to the jury.
I might put my dogs out again real quick.
Resume at 10:05. Good morning. You can be seated. Does the witness have anything that she needs to set up?
No, she's testifying based on her review of the file. She does have some notes with her if she can't remember something.
That's fine. All right, please stretch your legs or use the restroom if you need to. We'll try to
Linda
start again at
Bailey.
10:05.
Thank you, Your Honor.
She's an expert, but it doesn't say what Linda Bailey is an expert in. Just that she's an expert. So, I mean, I think they were trying to use her in a way to like show that despite Donna's efforts, she really actually played no role in what actually happened during the divorce and the court proceedings and all of that. I think that's what they were trying to get at, which, I mean, okay, like she may not have talked to the lawyer that much, and they may not have used all of her, crazy things she said, but this still doesn't mean just because she wasn't involved in court, she wasn't involved in a whole bunch of shit, because she really did try to involve herself in all of that. So I don't think it was, I think it was neutral. That witness, in my opinion, is neutral. As a matter of fact, I think it actually made Wendi look a little bit better. Because listen, family court's a nightmare. All right. Majority of the time, both sides act like assholes. So, they did kind of show that Dan was a little crazy, but I don't think that it was really enough to make it seem like he was like that crazy, So she was all right. I enjoyed listening to her. I know many of you didn't, but I did. Family law is a nightmare. A nightmare. I don't know how people do it. It's not great. It's not great at all. So Bill said he said her testimony would be lengthy. Yeah, I'm thinking it doesn't say on the witness list like what she's an expert in. Oh, wait, no. I'm an idiot. I just saw the Esquire after her name. So she's a lawyer who is also an expert. I don't know of what, but she is. Buffy says, I mean, honestly, it can make Donna look even worse because as much as she tried, it didn't have any effect. So that means she was becoming a little bit more desperate. That's a very good point there that you made, Buff. So, yeah. I mean, when people aren't feeling like they're being listened to, yeah. Savage says Donna didn't have to pressure the lawyer. She pressured Wendi, who in turn pressured the lawyer, still involved. But it didn't seem like Wendi put a lot of pressure on the lawyer at all. It seemed to me that the lawyer was like, yeah, no, she just kind of let me do whatever. And she'd offer suggestions, but she was a different kind of lawyer. So I don't know. Oh, in financial law? I don't know. That's a good question. Yes, good morning, afternoon, Buffy. I thought she was, like I said, she's neutral to me. It didn't swing any other way. It was just nosy. And I like to hear about that. So you guys, we are on a short break. Now, earlier this morning, the judge said we were going to be on an hour-and-a-half lunch because he is going to let the defense finish up their witnesses for the morning. I think he said there are 4. These were the only 2 names I remembered. He said 2 more after that because somebody's arriving now in Tallahassee. And then the lawyer said, oh, we're going to need a longer break to talk. Because he was like, well, what are we doing after, these? And he was like, oh, we're going to need a lengthy amount of time to talk to our client about what's next. Meaning, is Donna going to take the stand? I did notice she was wearing a cream color cardigan today. She was wearing black yesterday. And I thought, oh, hope you don't take the stand in that. But today she's wearing a very light colored cream cozy sweater, which I do love cozy sweaters. But I kind of am like, are you dressed that way for when you take the stand? You just seem like an angelic, you know, grandma. I'm just a grandma, guys. So we'll see. We could get we're either getting Donna or the defense is resting today. I don't think court is going to end early because the judge is a little annoyed with the defense because the defense has not turned over like their witness list for the state. And we ended early yesterday because their witnesses weren't here, which, okay, fine. They should have been, though, because it was Tuesday. But so we'll see. I'm hoping. So let's manifest into the universe that we would like Donna to take the stand because we like mess. Because I'll be honest, I just want to hear her and Jackie. I guess I'm a glutton for punishment. I don't know why I'm like, yeah, I want to hear Jackie and Donna talk for like 4 hours. It's probably gonna be the worst, but we'll see. Yeah, somebody said they're trying to say that Donna wasn't all up in the lawyer's Kool-Aid. Yes, but Donna 100% told Wendi what to do. I mean, yes. I don't know. It was doesn't mean anything to me. I'll say this: it doesn't make it any less for Donna and her meddling. You know, because parents do like meddle in divorce, custody, child thing, and it's not uncommon. But anyway, so when we do have lunch today, you guys, I have to take a long break because I do have my appointment at noon. I think Terry's going to step in if the court's not over on lunch break by then. But she'll send you guys after lunch wraps up. She'll send you over to Midday Missing, and you should be sent back here. I still won't be back on till about 10 minutes before court is going to pick up because I have some phone calls I have to make today. Again, I don't know what those times are. So make sure if you haven't and you're watching that you subscribe and hit the notification bell so you don't miss when we get back live after lunch later today, because surely don't want to miss that if it's Donna. But I don't think we're going to court or to lunch until like 12:30 or something, probably. Yes, Midday Missing is back. This is Terry's. Terry had one on Monday, and today it's about it's about missing persons who don't get a lot of coverage for numerous reasons, including those that are considered not perfect victims, but we share their stories anyway. Try to get out awareness to hopefully find some of these people for their families and whatnot. So it's very, very good. And I recommend you just hang out, watch, give her a like as well during lunch while we wait. Scott says, what jail awaits Donna coming from Fremantle? I'm unsure of the geographic location. Oh, what prison? I think Florida. Does Florida only have one female prison? Probably. I don't know. Maybe not. It depends. She'll either go, depends how many female prisons they have. Like in my state, we just have one. If they only have one, and that's where Katie Magbanawat is, Donna could be shipped out of state. So we don't know. You can't really say in most cases what prison somebody is going to be assigned to. Because like once you're found guilty or you plead guilty and you're sentenced, in most states you go to like a check-in jail, if you will, usually for about 30 days, where they talk to you a bunch, they get to know your case and stuff and your security level, all of that, and then they place you in one of the actual prisons. It's usually like 30 days. At least it is here in Ohio. Not so sure about if all the states do it, but I do know quite a few do that. And then you go to whatever prison they assign you to. Now, if there's somebody else in that prison that you co-conspired with, sometimes they'll put you in the same one, but it's usually not great. One of them are going to have to be in protective custody, which would probably be Donna because of her age. But they could also ship Donna to a different state. Didn't they just do that with somebody that we were talking about last week or something? And I was Charlie. Yeah, Charlie, for example, is in South Dakota. Her son, he is not in Florida prisons. They shipped him to South Dakota, of all places, because of gang stuff. Because he tried to blame the Latin Kings for all of this, even though Lewis was the head of that. But anyway, so they could easily ship her anywhere in the country. They do that quite a bit, actually. So we won't know, but it will be public information if and when she is assigned one. So I know, let's manifest it. Let's manifest it. I'm all about it. Let's see. Okay, so we got Midday Missing tomorrow night. Terry and I will be on for True Crime and Wine Time, where we are covering part 3. That's the finale of the Aton Pates disappearance and murder. If that name doesn't sound familiar, and also known as the Milk Carton Kid from 1979. And it's going to be a doozy. It's going to be a doozy. It's another. We're covering the trial portion of the story, so I don't want to give too many spoilers. But I'll say this. This will be a case that I will be talking about again, I'm sure. So definitely come watch that. I do have some rants ready. That's tomorrow night at 8 p.m. Eastern. Me and the lovely Terry True Crime. As for the rest of the week, things are a little bit up in the air. So that's the thing. When trials wind down, it's like when they wind down, you're like, okay, well, things could begin or end at any time. So I don't really know what Friday is looking like yet. So I will let y'all know about that tomorrow because there might be some changes. Speaking of, look who just said good morning. Good morning, Terry. Good morning. You'll make ham Sammy's. But yeah, so, and then next week we'll have not all day every day, but we'll be covering the Cardi B civil trial, which is wrapped up. We'll be covering that Monday through Friday next week, but in smaller doses. It was not a very long trial. It was like 4 days. But that is what we're going to be doing next week. Watching while you get your makeup on and doing your hair. I love that. Love that for you. Yes, I heard it's a fun trial to watch. One, it's a civil trial, which we don't get to actually see a lot of televised civil trials. So even if you don't give a shit about Cardi B, which is fine because I don't either. I couldn't even tell you what she sings. I think she sings the WAP song or raps. I don't know what you want to call it. I don't really know her at all. I have zero opinions about her. But if you've never seen a civil trial, you might as well do a really short one. It's a good, because sometimes they can be lengthy. Like Debbie Heard was like 2 months, I think we watched that one. Oh my goodness. That was long. Oh, look at that.
Ms. Bailey of this information.
Well, whoever's listening on digital, if you can go ahead and look through the sidebars for Thursday and Friday to determine when the topic of Wendi Bailey as a witness was discussed. As I recall, I believe it was discussed that she would be permitted to be in the courtroom, whether or not there were any other matters that were discussed along with that. I cannot completely recall at this moment, but we'll review. And at minimum, Ms. Keppelman, exclusion is always the most extreme of remedies, and that is disfavored by the Supreme Court and the appellate courts.
I don't know
But
what remedy I could pursue, Judge. That was the only one that comes to mind.
well,
And I'd like them to stop violating the rule of sequestration. That would be the remedy I would say.
Oh, this witness
as
heard things.
related to the witness yesterday, I gave instruction concerning that.
I don't like her
Ms.
outfit.
Bailey will review the sidebar. At a minimum, you may question this witness concerning whether she has in fact tailored her testimony based on being in the courtroom.
Uh-oh.
Judge, I'm familiar with this witness. I don't think she would do that, but as we know, the rules are in place for a reason.
Oh, absolutely.
Things can happen without us knowing they're happening consciously. So that's why we
Second.
try to keep these witnesses isolated from each other.
You can let the jurors know I'm going to go to the court reporter's office to check the sidebar. From there, we will finish this matter and resume testimony.
So the second defense witness who has broken sequestration again. But I don't think it's going to be much ado about nothing. They're going over former sidebars. Georgia babes, I'm not loving your outfit today. All right. You look like either you're going on a safari, which, I mean, I guess if you're going hunting for Donnas, all right. I need to know the reason for this outfit because it's a little confusing for court. You're in a safari, or you look like you might be in like an old-timey war, like army person. I'm not loving it. I'm not loving it. But I mean, it's okay. As long as if you're hunting for Donnas, if you're hunting for Adelsons, it's fine. I'll allow it. Good morning, Sam. Hope you're doing well today. Good morning. Happy Wednesday to everybody. It feels like a Thursday. Whenever there's a holiday, it just throws off my whole everything for the entire week. And I hate it. But here we are. Yes, Savage. Jumanji. Thank you. Right? She just needs the hat. I mean, I know some people think it's cute. I do not. But nailed it. Yes. Jumanji. I did enjoy the one remake of Jumanji. I think there was another one, but I didn't watch it. Excuse me. So this person's qualified as an expert, though. So I don't know why. And they're a lawyer. Okay, because Esquire is next to their name. So they're a lawyer. They're an expert. And somehow they were sitting in, listening to testimony. So I don't know. I mean, the realtor guy, we cut him a break, all right? He may have never even has any idea about that. But and the judge specifically told defense yesterday that they needed to inform their witnesses about sequestration. Now, was this before or after they had that? We don't know. Today, Court TV likes to turn the feed on in the middle of a conversation, so we don't get the first half. That's what happened this morning. But yes, what was I talking about? I forget. Oh, Saturday, if you guys want to hang out with us, over on our Discord server, the Courtyard, I am streaming on Saturday at noon Eastern. I am streaming the full season of Dexter Resurrection. So if you want to come hang out with us, you can all sit there and type our thoughts in real time as we watch it all together. I've seen it and it's amazing. Love it. It's better if you're like a super fan, because there's a lot of fan service, fanfare in there, but in a good way. Because some shows do it, and you're like, oh my god, stop! embarrassing me. But no, they did a really great job with that. They may have been caught off guard this morning. Oh my gosh, the defense is having a day. All right. First, they wanted to bring in 2 new witnesses. We didn't find out who the second one was. The first one was one of the jail correctional officers. It was a whole thing that they had to swear a sheriff in to be like, I don't know. I mean, we didn't tell her not to cooperate, but we did speak to legal, and it's like her choice. So the judge was like, all right, well, I mean, if you want me to write a subpoena for her, fine, but she's not obligated for it, and the trial's almost over. So I don't think that's going to work out for you. They did not say, or I don't think they said exactly why. It sounds like something like she might have overheard something, or I don't know. We don't know, because they started right in the middle of that. And now we have another witness who apparently has broken sequestration. So that's fun. I love that. A lawyer, nonetheless. So that has been our day, which, I mean, the judge does not seem very happy about things today. So I don't think this will be like they are sloppy. They are. Okay. I'm sorry, but they are a mess. I know that they've only been on this case for about a year, almost, maybe a year at this point. But yikes. So basically they make me feel like, if you're worried you can't pass a bar exam, there's them. I think you can do it. Remember, not everyone aces a bar exam. All right. There's going to be a spectrum of competency. And I don't know what's going on with these two. They are a mess. They are a mess. Jackie is, oh boy, she's something. And the guy, he's trying. He's trying, but he's a mess too. It's just chaos for the defense team. And the crazy thing is these are private lawyers. They're paying these lawyers a shit ton of money. I mean, the one witness, what did we tally up that she probably overall it cost for her to come from the digital forensics, which we learned nothing from, really, just that there were less phone calls than what the state said, but she agreed to everything else. I think it was like 40 or 50,000. It was crazy. Which also, we all need to become experts in something. I'll do mine in SAS. Oh, hold on, I gotta let my dogs in. Be right back. Okay, sorry about that. Also, I know at some point, working out the details, at some point we're going to be streaming the Unknown Caller documentary in our Discord. If you haven't seen it yet, holy shit. It's so good. You will be angry. I don't know when exactly we're showing it in there, but if you have already seen it, no spoilers in chat, we do have a little section that you can go talk about it. There's spoiler warnings, so everybody knows not to go in there. But if you have seen the documentary and you have thoughts and feelings, we want to hear about them in our Discord server. Just ask somebody where the chat for that is, because numerous people have already saw it, and it's, oh my God, It's crazy. It's crazy. Elbow watched it last night because I've been bugging him. I'm like, we need to talk about this. And he's like, okay. And afterwards, like about every 15 minutes after it was over, it was like he had an epiphany where like he knew it was bad, but then as time kept going by, it just kept getting worse and worse in his brain. And I'm like, yeah, the more you think about it, the more disturbing and disgusting and pissed off and angry you are. And this one, like all night, every 15 minutes, he would just be like, oh, yeah, yeah. Yes. Thank you, Buffy, for that recommendation because I'm still not over it. I'm not over it at all. So I might talk about it more. I'll give it like a week of being out and then I'll probably talk about it on the show or something because we had to talk about it. I've never can't believe it. Anyway, it's really good. We're going to work on putting together an event in the Discord for that. I think Miss Shorty, though, Saturday, if you haven't, she's a friend of ours. Go check her out. But I think on Saturday, Motion said they're watching it over on Kick. So, but that will be full of spoilers if you haven't watched it, just to probably let you know. I don't know how they're doing that over there, but I believe they said that they're going to be covering this Saturday. So go watch it there if you want. Come over and chat with us if you want. Somebody will be there to be like, yes, you can just rant and rave in this section. Because you will. You will. I love it. Sam says, I have feelings, but I have not watched the whole thing yet. However, spoilers have been everywhere, and I can't even process what I've seen before. Yeah, it's... I have many, many of thoughts on it. It's... You can't say anything without ruining it, really. I'll just say I've watched a lot of true crime documentaries in general, and this one somehow is one of the most disturbing ones I think I've ever seen, where like I can't. I just can't. So go watch it. Netflix, Unknown Caller. It's a good time. It's only an hour and a half too. It's not like a series. It's just a regular documentary. So I wish it was a series. Afterwards, you're going to be like, wait, we need more info, please. And thank you. Because there is a lot of things that I wish was, I don't know if we needed them explored further, but I think we needed to extend the talking regarding certain information that they did a good job. They just touched on it all. But if you're not paying attention, then you might miss some of the significance of some things. Buffy says, I need a documentary on the documentary. Yes. Yes. He said what it's called? It's called Unknown Caller, the high school catfish. It's on Netflix. I don't know if it's on Canada's Netflix. I think we usually have the same shows. Yeah. If it's not, Dave, there's been talks of us streaming it in the courtyard. So if you don't have access to that, pop over there. We got you. We got our foreign friends. If they don't have access to it, then definitely join. And you'll be able to see it. But yeah, still not over it. Okay, well that's supposed to be a cute story, Angie. Oh gosh. Okay. Hmm. Oh, okay. I see. Oh, it's kind of a creepy story. It's scary. On top says, I haven't seen it yet. I've got a copy. I'm waiting to see it here. I mean, it's good stuff. Dave, I have ways around everything. I bet you do. You did catch a trailer for it, and I do know what happens. I'm not saying a word. Yeah, but like to hear it is unbelievable. Like unbelievable. There was a ranting at the TV, both by myself and by Elbow Feet, because it's all I know is that I'm obsessed with it. Don't worry, no spoilers here. What else do we have to talk about? Why is this break taking so long? I do feel like the defense is delaying a little bit today. Oh, you knew the story too? I did not know the story at all. So I was really caught off guard. Like, say what? Buffy said, yeah, I literally did after they revealed it. I was the same. And Elbow Feet was the same as well. Like, so it gets to that point, right? And the dogs run out. So he pauses it because he thinks, oh, it's fine to pause. Like, no way. And I was like, oh. Thank you, Simone, for the super chat. Appreciate all of your support and being here every day. Says you guys are amazing. Mad respect. Same to you. We're so happy to have you here. And thank you for your support, Simone. Appreciate it. And the doc didn't cover everything. There's a lot more. Yes, I put in our little chat about that. I put a link to an article. I think it's from The Cut that came out in January. So before this came out. And there was some additional interesting information in there as well. So I'm still going down rabbit holes and all. So, oh goodness. Oh, you read that article too, Buff? Yeah. I feel like there was a New York one too that I've heard about, talked about, in the Reddit. Reddit's freaking all over this. I'll tell you what. Crazy. Love it. What are we watching now? We're finishing up the most recent season of Only Murders in the Building. That's what Elbow Feet and I are watching and finishing up probably tonight. Maybe. Because I realized I didn't actually see it all. I don't know what happened when it came out, but we only got to like episode 5 and then never finished it. So I was like, okay, well, we'll finish it now. Plus I love Martin Short and Steve Martin so
Hot from the
much.
presses from our very capable court reporters. Has everyone reviewed the transcript at this point?
Yes, sir.
Please make your arguments.
No.
Judge, I mean, I think it's clear from the totality of this that I am agreeing for their experts to review the testimony of other experts, and that in reference to lay witnesses, experts are not going to listen to the testimony of lay witnesses.
Mr. Zellman.
Judge, on page 62, we specifically said Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies. And then I addressed our forensic expert to share the transcript of Sergeant Corbett's testimony. Certainly, I see later where we're discussing as the lay witnesses, page 63, starting lines 11 through 14, as to the lay witnesses, so non-experts, other than Linda Bailey and Kelsey Guy, to be able to observe witnesses. We were not asking for that.
as to both the context and the discussion is concerned, an adverse expert listening or reviewing or listening to the testimony of the other expert. Ms. Adamson was called as a part of your case in chief. Ms. Bailey is being called in your case in chief. Ms. Adamson was not an expert. The state never agreed to what is being discussed.
That's true.
Why
Judge,
should this witness be permitted to testify? Mr. Zolman?
Judge, the prior page specifically says that Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies.
You brought this up, yes, but the state made no agreement as to anything but an adverse expert as to observation of testimony that would otherwise go to the rule of sequestration.
Judge, with respect to the context and the statements, we were obviously asking that.
It's in black and white. I know what you asked. What happened though is the opposite of that. As to that, what is your argument now?
Your Honor, exclusion of a witness is an extreme remedy, as you recognized previously. We took the court's, this conversation to authorize Ms. Bailey to be present during Kristen Adamson's testimony. And that is what we advised the witness when we spoke with her later in the week. But for this conversation, we would not have done that.
This is the second time in this trial where a defense witness has been in the courtroom inappropriately in violation of the rule of sequestration. When this was addressed at sidebar, you brought up the topic, but the state only agreed as it related to your expert reviewing an adverse expert, their expert's testimony. That has not been the case today. Why have you not been more careful with this individual or even brought up this topic to make sure we did not end up in this point in place?
Okay, so
I
disappointed.
thought we adequately addressed it last week when we were in the sidebar.
Ms. Cappelman, what are you asking for?
Seeking exclusion, Your Honor.
As to exclusion, what is your argument?
That this is not the first time this has occurred, that this issue was addressed at sidebar, the ruling was clear, that witnesses, that our experts would be permitted to listen to, and only in that circumstance and that particular exclusion, which we're all familiar with in the rules, the other side's experts. So I'm just a little miffed that here we are. I didn't ask for any exclusion the first time this happened, or really any remedy. But you did admonish the defense to not let it happen again, and now it's happened again. So, does the state get a fair trial too? Do we get a remedy when it's the second time that the rule's been violated? I think it's appropriate. So.
I forgot she has animal print glasses. All right. That does.
By the rulings of the Supreme Court and the appellate courts, I don't get to make it up on the fly. Clearly, this has happened twice, but moving to exclusion, again, is the most extreme remedy.
Judge, if I may,
Last word.
viewing Earhart, exclusion of the witness. Court may exclude the witness only if it finds that the testimony of the challenged witness was substantially affected by the testimony to be heard, to the extent that his testimony differed from what it would have been had he not heard testimony in violation of this rule.
Which is why I believe you wanted Ms. Bailey to listen to Ms. Adams' testimony first.
Are those chili? Is
Sorry?
it spicy?
You wanted Ms. Bailey specifically to listen to Ms. Adams' testimony for a reason.
I think so. I can't really
Our
tell.
expert requested it, yes.
As it relates to what you just read in that passage, how the expert's or the witness's testimony somehow would have changed or been affected.
I think the only way to determine that is to speak with Ms. Bailey concerning her testimony.
Ms. Bailey come to the witness stand so that Crawford can be taken on this matter. After that, I will step down, briefly review what I need and make a ruling.
Oh, so she was still sitting in the gallery then?
Please raise your right hand. Do you
Okay.
swear or affirm the testimony you're about to give will be the truth?
I do.
Please be seated.
Oh my God. All right. I got to go to the bathroom. I'll be back.
You may inquire for the purposes of the proffer.
Thank you, Your Honor. Good morning, ma'am. Can you please introduce yourself to the court?
Yes, my name is Linda Bailey.
And Ms. Bailey, were you retained as an expert on behalf of the defendant, Donna Adelson, in this case?
I was.
Specifically in what area?
The scope of my requested testimony was to evaluate the divorce docket, pleadings, motions, orders, etc., in the Adelson-Markel divorce, and to opine whether or not the divorce would be exceptionally contentious or unusual within the context of a family law case.
In the course of preparing for your testimony, can you briefly summarize what you reviewed?
Yes, the primary source that I reviewed was the family law pleadings, motions, notices, orders that were provided in a prior litigation in this matter. I think it was an exhibit from the state which detailed all of the pleadings in the family law folder. So that was my primary source. Then other than that, I spoke to Ms. Adamson for about an hour a couple of weeks ago just to confirm what I supposed were facts. And I have known Kristen for 40 years. We went to law school together. And I know how she practices. I practice against her often. So I had some ideas about the lack of strength of Mr. Markel's motions. And she agreed. I read her prior testimony in one of the other trials. I think it was Charlie Adelson's trial. I reviewed some exhibits, but they weren't very helpful to me. They were, one of the officers had done some sort of a PowerPoint presentation with faces and arrows and timestamps for communication, and I don't even know why those were provided. I didn't take anything from those. I reviewed.
Did you review some emails?
I reviewed texts and I reviewed emails. So I reviewed emails between Donald Adelson and Wendi Adelson. There were a couple between Donna Adelson and Charlie Adelson that were much later, but they happened to be in the tranche of documents that I had. I reviewed text messages between Wendi Adelson and Dan Markel. I read some text messages between Donna Adelson and Wendi as well.
And in preparing for trial in this case, did you request court authorization to sit in on the testimony of Kristen Adamson?
I did.
And why was that?
Just to confirm that I had the facts correct.
Okay.
And I did.
And you sat this morning through Ms. Adamson's testimony.
I did.
To what extent, if any, is your proposed testimony impacted or affected by the testimony you heard from Ms. Adamson?
It was very consistent with what I believe the facts to be, so it didn't change what my opinion is.
Nothing further for purposes of the proffer?
Compliment. An examination for the purpose of the proffer.
You said it was very consistent with what you knew before. Was there anything new that you learned from Ms. Adamson today that you had not learned previously in your
No, I don't.
preparations?
I think so.
No, Your Honor.
Please step down, Ms. Bailey. Return in a few minutes.
Oh, did I miss it? Oh, was it anything interesting? What? Bailey, most divorce cases are contentious. Yes, they are. Yes, they are. That's why family law sucks so much, because it brings out the worst in people. It really does. It did not explain why Donna washed money. Interesting. Donna's lawyer is such a mess. She shows at the men's bargain basement. I don't know. I feel like those are suits from like Goodwill or some shit like that. I mean, to each their own, but like, ma'am, you are a tiny little person. Oh, and we know you make good money that you could probably afford a tailor. Just saying is all. Okay, well, are they bringing the jury in or are they discussing something? This is going to be such a long day. Oh, Lady in Gray, let's go back up to your comment earlier that you put in this one. So, Surviving the Survivors said that Donna's defense requested an entire delay for today so Donna could rest. Judge said no. I wonder if that was one of the things they were talking about this morning, because again, the feed only keeps starting in the middle of things being discussed. So I was wondering if you know more about that. To physically wash money. I know, right? It's so weird and bizarre, but here we are. That's the thing about court. They are weird and bizarre. I don't know if there's been a trial that I've seen where I haven't been like, oh, everything was normal. All the witnesses were normal. There's usually little things here and there that you're just like, wait, what? What? Oh, you think it probably was from this morning? And she gets a whole day to rest. What is she doing? What does she need a day to rest for to take the stand? I would have said no, too. Be like, ma'am, you knew you were wanting to take the stand before this trial even started. So you're fine. I get it. She probably has to get up at like, probably like 3 a.m. in jail. Because she's in a county jail right now. And usually they start transporting people that have to go to the courthouse. Here they start transporting them at like 5 or 6 a.m. So you usually have to be up by like 3 or 4. They transport you over because then they usually have like a little jail in the courtroom too, where they keep, defendants who have court. So it's a whole thing in the morning. I bet she is tired, but you know what? It's too bad, huh? Too bad. Here we are. And I would think, if I'm really wanting people to believe me and be all innocent, I don't need to rest. What do you need to rest for? To say words? Doesn't make any sense. More delay tactics, I feel. Oh, that's interesting. Well, great. Love this for us, team. It does mean that today we won't get to play our word game unless there's a even bigger break. Which is probably this one. Do we know why they're on break right now? I missed the whole thing. I had to let the dogs out and go to the bathroom and get coffee. All that fun stuff. What do you guys got for snacks today? I still have some nerd gummies left. Some Jolly Rancher gummies too. Good morning, Kelly. Good morning, babes. Hope you're doing well. It's been an interesting morning here. So, another defense witness broke sequestration again. And I can't believe she was just sitting in there while they were talking about it with the judge. Like, why was she still not outside the courtroom? It's weird. Sam says, boo-hoo, Donna. Here's a tissue. Now get up there and take the stand so we can move this along, ma'am. Right? Like, oh, goodness. Savage says Jimmy Dean's sausage delivery truck overturned outside the courthouse. Judges helping with the cleanup. I mean, with prices today, I will too. I will eat roadside. I'm not going to finish that sentence. I ran it through my head before it actually exited my mouth. So I'm not giving you that freebie. What happened? Oh, Kelly P. There's just today the defense is just all over the place. Let's see. They wanted to bring 2 new witnesses, and that didn't really go through. According to a tweet or an what do you guys call them? I don't know. Defense asked if Donna could have the whole day off to rest before testimony. That was a no. Then we had the first witness of the day was Wendy's divorce attorney. She was on the stand for a good hour-ish, hour and a half. Nothing really groundbreaking from there. We're not really sure why she was even called. I personally found her just be a neutral witness. It didn't help or anything for me. And then we're about to bring on Linda Bailey, who is also an attorney and an expert at what? Don't know. But then it turns out that she was actually sitting in the courtroom again. Another defense witness, like yesterday, was sitting in the courtroom listening to the previous attorney's testimony or whatever. So they've been arguing about that. They just did a proffer with her. I did not catch the proffer because I had to do a few things, and I thought it was going to be longer than like 2 minutes. And so here we are. Here we are. I don't know. They're supposed to have like a total of 4 witnesses today before. I need to get those. They're so good. I forgot my mom had gotten those for Halloween, and I took a bag of them. Oh, they were awesome. So yeah, so that's what's been happening today. Donna may or may not take the stand. We'll find out this afternoon for sure. Dave says, hi, Kelly. Did the dentist say you have the whitest teeth he's ever come across? I hope so. Then she's like, no, I had 2 root canals. Well, I'm still sure you probably have a beautiful smile either way. So, and I'm sorry, that sucks. Yes, I'm with Sam. Hopefully you're feeling better today. And yeah, it's been interesting day so far. The defense is very scattered all over the place. They're very disorganized. Ugh. But so there you have it. Honestly, trying to make sense of their entire case so far is, I mean, gosh, of the witnesses we had yesterday, I don't think there was a single one that really helped with anything. I mean, the character witnesses they brought on, the friends, I mean, okay, sure. People can be nice to you, or, people do all sorts of things that you wouldn't expect them to do behind closed doors. So it doesn't really mean anything. Oh, did you know that she was conspiring to kill her daughter's husband? No, I didn't. She never brought that up ever. Of course she didn't. Why are we even talking to you? Though I must say, Anne and Ron were adorable, and I wish them the best in their lives. They were cute. And then who were even the other witnesses? God, I don't remember. That's how not helpful they are. I also feel like they're just calling these witnesses because the Adelsons are footing the bill. So they're probably wanting to. I mean, God, if Donna was that involved with Wendy's divorce attorney, I can only imagine how involved she is in this one as well. Who else did they call? Let's see. That was their friends. Friends. Oh, we had Eddie Varnes. He was an investigator. He went to talk to some of the jail informants, which then the defense plays. The defense plays this video yesterday of the jail pod. And down in the corner is Donna and Drina, one of the jail informants, her prison daughter. And I still don't understand why the defense played it, because they're at the table and they're just talking. Then there's notebooks. Then there's paper all out on the table, right? Drina is the witness that said that Donna had made a script for her to testify and lie about certain things. And I don't understand why the defense showed this, because, yeah, we don't know what they're talking about or what they're even writing about. Okay, you're right, we don't. But what you're showing is that most likely probably is that video had never even brought in. Why they brought it, I don't know. It was not great for their client. Oh, yes, we did.
Concerning this issue of the testimony of Linda Bailey, the court is going to find there has been a second violation of the rule of sequestration by the defendant. The matter that was discussed at sidebar brought up the issue of the witness sitting in court. However, the state made no agreement beyond an adverse expert listening to the testimony or reviewing the testimony of their expert. With no other ruling being made on the issue, Ms. Bailey should have not sat in the courtroom.
She shouldn't
The
have.
test for determining whether a court may properly exclude the testimony of a witness for violating the rule of sequestration is whether the testimony of the challenged witness was substantially affected by the testimony that the witness heard, to the extent the witness's testimony differed from what it would have been had the witness not heard the testimony. And this is citing to a Florida Supreme Court case, Steinhorst versus State, 412 Southern 2nd 332. The same test also applies to expert witnesses who violate the rule. Concerning the proffer, the witness has indicated that in preparation for her testimony, she reviewed materials provided by the state. She reviewed testimony from the same witness from prior trials, and ultimately her opinions, whatever they may be, to be offered, have not been affected. As a member of the bar, I am going to give credibility to what Mrs. Bailey has stated concerning these matters, as I have no other evidence to the contrary. Although the state has asked for exclusion of this witness, this being a second violation, it still remains inappropriate. Concerning how the jury is to be instructed at the end of the trial as to this testimony specifically, if the state is asking for instruction for how the jury is to weigh the credibility of Ms. Bailey or the previous witness who is subject to the rule of sequestration, I believe they are entitled to based on the circumstances of this matter. Does either party need to be heard further?
As long as the instruction that the court is going to give the state's going to specifically be asking for, ask the jury to determine whether the witness's testimony was impacted by what they observed.
We can wrangle over the language at a later point.
I have no objection as long as we can agree on the language.
Please bring in the jurors. Miss Bailey, please come to the witness.
Well, she gets to testify, I guess. We'll see.
If there are any additional matters that need to be clarified, this needs to occur so we don't have any more issues with witnesses or other problems.
Because anybody else sitting in the courtroom, you guys, that's what he wants to know. The judge said, oh, I give her credibility because she's also a bar member, a lawyer. But I'm like, wouldn't she know even better to not do that? But what do I know? Did you guys see her ears? She has some elven qualities. I know Savage talks about the elvens quite a bit. I think you got a candidate here. You'll see.
Everyone can be seated. Ms. Bailey, please rise to be sworn. Ms. Bailey, please rise to be sworn. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may take your seat. You may examine as you're ready.
Oh, she covered them up.
Good morning. Can you please introduce yourself to the jury?
Yeah, my name is Linda Bailey, and I'm a family law attorney here in Tallahassee.
Tell us briefly about your educational background.
My post-high school educational background is I have a bachelor's in psychology from Florida State University in 1983. I worked for a couple of years and went back to law school in 1985 and graduated FSU Law in 1988 with honors.
So math isn't my strong suit, but that's
37 years.
37 years.
I went to school with Miss Adelson, so
Okay.
we've been practicing the same length of time.
What type of law did you initially practice when you graduated?
When I initially, during law school, and then after I graduated, I initially practiced criminal defense law. Then I brought in slowly a family law practice. And then in 1994, about 6 years into practice, I shifted my focus to solely family law and went on my own and opened my own practice.
So since 1994, have you exclusively practiced family law?
Yes.
Oof.
Can you tell the jury approximately how many family law cases you've handled since then?
Oh, I tried to count those for this trial, and my best guess would be around 2,000.
Do you have any certifications?
Like Kristen, I am board certified in marital and family law. And what that requires is an application that's about 3/4 of an inch thick that details all of your trial practice, litigation practice, the type of cases you've handled, how many experts you've done direct exam with, cross-exam with, et cetera. Then once you provide your application, the bar does a peer review, and that includes sending very detailed questionnaires out to opposing counsels and judges in front of whom you've practiced. And then based upon that peer review, they will invite you to take the exam. The exam is a 6-hour exam done in Tampa. And I think the year I took it, 41 people sat for it, and I think 9 passed. So it's a pretty rigorous process.
Okay, and before we continue, the clerk had asked me to have you spell your name. Can you spell your last name, please?
Yeah, Bailey.
Thank you. How many board certified family law attorneys are there in the state of Florida?
I
Who
believe there are
cares?
about 274, according to the Florida Bar.
And do you know what percentage of lawyers in Florida are board certified in marital and family law?
I think less than 1%.
What do you have to do to maintain your certification?
Well, ordinarily, lawyers have to do a 30 hours of continuing education every 3 years. To maintain your board certification, you have to recertify every 5 years, and you have to do 75 hours of continuing education every 5 years. So there's an enhanced legal education, continuing education requirement. And then you also have to continue practicing in the area where you have a certain number of trials of a certain length of time that you also have to do within that 5-year recertification period.
I just go off
You
every
also-
And they also
Wednesday.
send more peer reviews out every 5 years. So all of the other opposing counsels, other board certified lawyers in your community get a questionnaire, and they get to fill that out about their impression of working with you, and that goes back for your recertification.
And judges also get that same peer review.
They do.
Do you have any other certifications?
I'm a Supreme Court certified mediator, and
And
that
now-
was probably the very aughts, 2000.
Oh, maybe she was the
I can't remember
mediator
exactly when
then.
that was.
Okay.
What's required to be a certified mediator?
It's a 40-hour course. I went to Orlando Monday through Friday, and then after the course, you do co-mediations with other mediators, and then you have to do some supervised mediations, and then you're certified. They have the same recertification period, not as enhanced as a board certification, but you do have to take enhanced continuing education that might be a little bit different than you do for either your bar license or your board certification.
Have you maintained your board certification since you were first certified in 2011?
Yes, I have.
Have you received any other recognitions during your career?
Well, U.S. News and World Report puts out a Best Lawyers in America publication annually, and I've been recognized in that publication for many years. I'm not sure how many. They've also recognized my law firm as Best Law Firm in America, and recognized me as a woman in the law to watch. I also have been recognized as a super lawyer, which means the U.S. News and World Report bases their recognitions
I haven't
on
heard of that.
peer review. And the enhancement at the super lawyer is it does peer review. It also looks at your practice, your certification, your outside legal interests. Like, have you provided presentations? Have you taught? Have you done certain community service or pro bono work, that sort of thing?
Have you taught?
I have. I taught for several years. I'm going to estimate 5 years with the Legal Aid Thunderdome program.
She's smart enough to know
And that's
that
really
you don't
an
get a cape.
incredible program where family law attorneys, now it's grown to do other disciplines. But at the time I was doing it, it was strictly to teach other lawyers who don't do family law how to do family law well enough to provide pro bono services, free services for people who can't afford lawyers. And my focus in that area of teaching was parenting plans, parenting schedules, relocation, those sorts of parenting related issues.
Your Honor, we would tender the witness as an expert in family law proceedings.
The state wished to voir dire the witness as to their training or experience. Any objection to her ability to provide an opinion in the fields of marital family law?
No, Your Honor.
Members of the jury, the witness will be
mean,
permitted to
she
provide
is a super
opinion
lawyer.
while she testifies in the areas of marital and family law.
Is she a human though?
Thank you, Your Honor. In conjunction with your being retained as an expert in this case, can you tell the jury what materials you reviewed?
Yes, my primary source was the divorce file between Wendi Adelson and Dan Markel. So everything from the petition that was initiated in September of 2012 by Wendi Adelson to the last document filed, which was, I believe, a suggestion of death.
And did you review any other materials?
I reviewed text messages that were provided to me. I believe they came through the state between Wendi Adelson and Dan Markel in the 2014 timeframe. I was provided, but didn't review thoroughly, text messages between Wendi Adelson and friends and other miscellaneous texts. There were some text messages between, I believe, her and her mother.
They're fine bills, but thank you for
most
your
of their
concern.
Communication, I think, was by email, and I reviewed the
The socks are
emails
working.
that I was provided between Wendi Adelson and Donna Adelson from maybe 2011 up through about 2017. I don't know if they were comprehensive because they were provided to me.
Did you also speak with Ms. Adamson concerning her representation of Wendi Adelson?
I did. I spoke to her for about an hour a couple of weeks ago to kind of confirm my impression of some of the motions that were filed.
Now, can you you indicated that you reviewed the court file. When was the dissolution of marriage action begun?
It was begun with a petition filed actually by Wendi, which she had a lawyer, Shannon Novi, for a brief period of time, and then she switched to Kristen Adamson. So I reviewed that petition, and that was filed mid-September 2012.
Did Wendi Adelson in that process file a motion for the court to determine a temporary parenting schedule?
Yeah, just about a month after the initial petition, she filed a motion for the court to order a temporary parenting plan,
Hello, Lainey.
which is normal, so you don't have
Good morning,
chaos
babe.
pending a final resolution.
So that filing of that motion is a typical step in a dissolution of marriage that involves children.
Well, it's very routine because what you don't want is both parents showing up to school, picking up the kid on the same day, and the kid doesn't know where they're going. And it creates a lot of stress for the children if they don't have a plan. So it's important for the parties to get together early on and figure out what they're going to do until the court can make a final ruling.
And what specifically was Wendi Adelson's request in that temporary parenting plan concerning time sharing?
She asked for a plan that would provide 51% of the time to her and 49% to Mr. Markel, which at the time, it was much more traditional, if you will, for there to be a primary parent and a secondary parent. And it was thought at that time that having a child more solidly in one household versus splitting the 50-50 was more advantageous for the child. That thinking has now changed where there's a presumption of 50-50, but back in 2011-12 time period, she had initially filed for majority time sharing, which was ordinary, but then actually in her motion for temporary parenting, she asked for a 59-41, which is 51-49, which is essentially 50-50.
Why would one party ask for 51-49?
Really, the only reason I can think of would be for an IRS tax advantage. So you'd be able to claim the children on taxes.
To claim them as dependent?
As dependents, yes.
Okay. Or head of household?
Yes.
Okay. Now, you indicated that a lot of times these issues, it's important to establish them early on. Did Wendi Adelson and Mr. Markel have to go in front of the judge to get a temporary parenting plan put in place?
No, they worked that out by themselves, or through counsel.
So they worked out an arrangement that was beneficial for the kids and allowed them to have time sharing.
Yes, my understanding is they worked out a 50-50 arrangement.
Okay. Now, we're using the term time sharing. We also have, during the trial, heard the term custody. Historically, has the term custody been used in family law proceedings?
Not for many years. Gosh, it may have been a term back when I started practicing, but then it went to primary residence and secondary residence, and then it moved to simply time sharing. So there's been a change in the way we refer to it linguistically, because you don't want a secondary parent. You want all the parents to feel like they're full parents. So.
And so the term custody is not something that is used in family law proceedings any longer.
Not between parents. The term custody still lingers in some grandparent cases, which aren't applicable here.
Okay. But when we're talking 2012 moving forward, the term custody was not used in family law proceedings for dissolution.
Correct.
Okay. And the term at that time was time sharing and parenting time.
I believe back then it had shifted to time sharing. It may have been primary and secondary residence, but I didn't see that in the petition. She just asked for majority time sharing. So that must have been when that law switched. It was around that time.
When Wendi Adelson initiated this dissolution, did the pleadings indicate that she was trying to prevent Mr. Markel from having substantial time sharing?
No, I didn't see anything throughout the whole file. She tried to prevent Mr. Markel from having substantial time sharing.
Can you tell the jury what is substantial time sharing?
Well, substantial time sharing, again, the definition has changed. It used to be more, in this era, it was more than 40% time sharing. And now for the purposes of child support adjustments, it's kind of been reduced to 20% or more. But I think when we're talking about time sharing versus how it impacts child support, substantial time sharing, I think everybody would accept would be 40% or more time sharing.
So in other words, when Wendi initiated the dissolution against Mr. Markel, she was not trying to prevent him from having 40% or more of the overnights.
I never saw anything other than the 49-51.
In your review of the family law pleadings, can you tell the jury how many contested hearings took place prior to the final judgment being entered?
From my review of the pleadings, one partial hearing occurred, and that was the June 21st, 2013 hearing on Mr. Markel's motion to dismiss the petition for relocation. And then he had filed a motion to enforce life as he would have liked to have seen it. And then the relocation was all within one hearing. The court adjudicated the first two issues. His motion to dismiss was denied. His motion for enforcement was denied because there was nothing to enforce. There was no court order that required the things he wanted to enforce.
So,
and then,
in other words, he was asking the court to enforce something that they had agreed on, but hadn't been a court order?
well, I don't even know that they had agreed on things. He had kind of a sense of the way he would like to see life, which had to do with being really intrusive at Wendy's home. He wanted to go over there often during her time sharing. He wanted to have a great deal of contact. He wanted video contact, things like that. And so, and I think there was maybe a recommendation, I could be confusing this with a later motion, where the child care owner had made a recommendation about something and he wanted to enforce the recommendation from the owner of the child care. None of those were enforceable because they'd never been ordered by court or even put into any sort of formal document. So that was denied.
So he would, let me understand correctly, he was asking for court authorization to be able to go over to Wendy's house?
In that particular motion, I could look at my notes, but I don't remember exactly the detail. Ordinarily, when you file a motion for enforcement, you have a court order that
if we get a break
says
before
the
my
other side
appointment,
has to do A, B, and C.
otherwise I'll definitely show
And if
them
you
for the
don't do A,
afternoon
B, and C,
stream for
file a
you,
motion to
Kelly.
enforce. But you can't enforce an email communication back and forth where you said, you know, you can have them on Tuesday, and then Tuesday you change your mind. There's no court order to enforce. They just changed their mind. So he was trying to enforce conversations that he had had with Wendi that had no court-ordered basis.
Okay. Now, you mentioned the motion, Mr. Markel's motion.
I don't think they're helping.
Petition for relocation, his
say
motion
that.
for enforcement. Was that also the same hearing where the relocation petition was heard?
The same hearing.
Okay. And based on your review of the file, what happened at that hearing?
Based on my review of the file, the court adjudicated his motion for enforcement and denied it, adjudicated the motion to dismiss and denied it. And he was basically saying that the petition for relocation was baseless and that the court should deny it. And the court said, no, it had merit, so we're not going to dismiss it. And then my understanding is before the hearing finished, Wendi essentially capitulated and said, okay, I'll agree to the denial of my relocation. And what's consequential about that is if they could have continued the hearing, finished their testimony, and appealed.
Look who's decided to join us
So
today.
by her capitulating and
Here's the
stopping
beauty.
hearing midway, she waived her right to appeal.
Hi.
Subsequent to the June 21st, 2013 hearing, did Wendi Adelson and Mr. Markel resolve the other issues in their dissolution of marriage?
Yes, on July 31st, they signed a full marital settlement agreement that addressed all issues. So within 5 weeks of the denial of relocation, they resolved all their financial issues. Wendi waived alimony. They adjudicated child support. They put into place a parenting plan, which is kind of also new lingo. A parenting plan is kind of the overarching rules on how you make decisions, how you communicate, who's able to go to events for the children, plus the time sharing schedule, plus communication provisions, how often you can speak to the children. Sometimes, like in this case, it was very general language, maybe what school the children go to. So they resolved everything 5 weeks later.
Now, the marriage settlement agreement also put in place a
pretty
parenting
quick.
coordinator.
It did.
What is a parenting coordinator?
A parenting coordinator is a professional, generally a lawyer, but it can be a therapist who is trained. I think they do a 40-hour course too, but I'm not certain. And they have a certification. And what they're trying to do basically is teach people how to communicate, teach people how to be reasonable. There's no parenting plan that you can draft that deals with all contingencies. People are always going to come up with something, and we don't have a provision in the marital settlement agreement to deal with that. So a parenting coordinator helps people set, for example, communication guidelines. Maybe one person is calling 10 times a day, and that's overbearing and it interferes with the other parent's life in households. So a parenting coordinator may help them reach agreement on what a reasonable communication might be. Maybe it's once a day at 7 o'clock. Maybe it's every other day. Maybe it's 2 times by video and 4 times by, telephone or something like that. So they help them work out the details and just keep the conflict low.
Now, can a parenting coordinator put in place provisions in parenting plan that are not already included in the marriage settlement agreement?
No, the parenting coordinator's role is to help the parties have a civil discussion and come up with a reasonable resolution. But if there's no reasonable resolution that they accept from the parenting coordinator, then they could go to the court and ask for a remedy in certain circumstances.
In certain circumstances?
Yeah, for example, the parenting coordinator is not permitted to add provisions that are not in the marital settlement agreement. In that circumstance, you can't just go to the court and say, hey, I want this provision added. You have to file a supplemental petition that requires a material and substantial change in circumstances plus best interest. Kristen talked about that earlier. And it's basically starting a case over. It's very difficult to modify a marital settlement agreement. What you can go to the court for that a parenting coordinator might be involved in is somebody's not returning the child on time chronically or violating communication provisions that are already in the marital settlement agreement. You may go to the parenting coordinator first to try to avoid court and say, hey, can you get her to stop? Can you get them to be more timely? Can we find a new meeting location, something like that? And you can go to the court for those types of issues, violations, but going to the court for modifications isn't going to happen unless you've had a material and substantial change. And the case law says that has to be an extraordinary change. So it's very difficult to get a modification or add terms.
Now, with respect to the Adelson Markel case, other than that June 21st, 2013 hearing, were there any other, did they litigate any other issues?
During the divorce?
Yes.
Up through July 31st?
Yes.
No, they resolved everything. Temporary parenting, permanent parenting, support, property.
How many months elapsed between when the initial petition for dissolution of marriage was filed and when the final judgment of dissolution was entered?
10 months.
How does that compare with cases that have similar issues?
If you take the relocation issue out, it's probably
Mhm.
average. If you add the relocation, it was brief. Most relocation cases take 2 years or so to get to trial. And
2 years is actually pretty reasonable.
As of the final judgment of dissolution on July 31st, 2013.
So they try to
What would be
push it in
your
like a
opinion
year
that
here.
This case was in any way unusual or highly contentious.
No, to the contrary, it was settled amicably and everybody was moving on with their lives.
And quickly.
Yes.
During the underlying litigation, so between September of 2012 and July 31st of 2013, when it was when the final judgment was entered, did either party file a motion to compel against the other?
No, and what that is if you're upset with the other side because they're not providing either the required financial documents that Ms. Adelson spoke about earlier, or if you do a request to produce more documents and they don't comply, then you would file a motion for the court to compel them to provide those documents.
And that's what we call discovery.
Correct.
Were there discovery fights here?
No, there were no discovery fights. There was afterwards when Mr. Markel's lawyer was trying to depose Wendi about the money he had not paid. But prior to July 31st, there were no discovery fights at all. There were, I think, requests to produce, and there was no motion to compel or any complaint about the responses to those. I didn't see any third-party subpoenas to banks or holding companies or brokerage accounts or brokerage companies.
Can you explain to the jury what a third-party subpoena is?
Yeah. So, for example, if you believe that a party has an asset that they're not disclosing, and if you know, in general, sometimes we do kind of blanket ones, but generally, if you know where those documents might be held, whether it's Fidelity or Wells Fargo or Bank of America, then you can do a subpoena. You do a notice first, and then you have to wait 10 days. And then you can issue the subpoena directly to the bank or the person holding those records and ask them to provide you the records directly, so you don't have to get them from the other party. So sometimes we'll have parties who just don't cooperate. They don't provide anything. We know they have retirement accounts. I have one right now, and he will not give us his retirement account because he does not want it split. So we are having to send third-party subpoenas out to all his prior employers to get his retirement records because he's just not doing it. So it's an easier way to get those records than fighting him directly.
And so in that type of scenario, you'd have to first subpoena his records from prior employers in order to get the names of the retirement companies, correct?
If I need to do that, they could be company-held employment plans, depending on what kind of company,
But potentially in that scenario where you're having to issue third-party subpoenas, there are multiple layers that you might have to go through in order to get the information that the other party is not providing.
No, it's really more direct than that. I mean, once you file your notice of intent to subpoena a third party, you issue your subpoena to that party. The difficulty comes if you don't know who the party is. Then you might have to take a deposition and find out where somebody's been working. Generally, your client knows where their spouse worked, so you have that information in that example. But there could be, like we have a case right now where there's like 140 something real estate properties all over the country. That makes it more difficult, obviously. So we're having to go into databases all over the country in different states to look for people and then find out who the management company is and then third-party subpoena the management company. But that's an outlier.
Needless to say, you didn't have to do any of that, or none of that had to be done for Wendi Adelson's divorce.
None of that happened.
What about non-party depositions?
What I saw was there was one non-party deposition from Dr. Phelps, who was the owner of Creative Preschool where the children went. And essentially, I did review that deposition, and it essentially said the kids were doing great. And then there was a deposition of someone who worked at the law school.
And aside from those two, I believe Wendi, was she deposed?
I don't recall seeing that Wendi or Mr. Markel were deposed.
Okay. Now, you testified earlier that you reviewed emails between my client and her daughter.
I did.
Did you find anything unusual about my client, Donna Adelson's involvement in her daughter's divorce?
No, we have parental involvement, as Ms. Adamson said, often. Sometimes it's employer involvement. Maybe they're very attached to their employer and they want to nurture them. Or we'll get siblings who are lawyers involved. So family involvement, and especially moms, I see a lot.
A lot of mothers?
A lot of mothers. They're worried about their
I
babies,
don't
no
know.
matter how old they are.
I don't know why we're here with another one of these
Now,
witnesses.
in the emails that you reviewed, did you see my client's use of the nickname Gibber, just,
I agree.
to refer to Mr. Markel?
I did.
Did you find that especially provocative?
No. I mean, gibbers means someone who speaks gibberish. And if you look at Mr. Markel's motions and memorandums and responses he filed in this case, it was somewhat applicable. He was very verbose. If you looked at his writings as a complete layperson, they may at first glance seem somewhat intimidating, but when you broke them down paragraph by paragraph, they were inconsistent. They didn't make sense. They referred to, in multiple situations, he was seeking enforcement of things that were not court ordered, even afterwards in the February 2014 timeframe. So he was very wordy. He would file a 16-page response, and then he'd file a 16-page memorandum that said the same thing, and then he'd file a motion related to that said the same thing. So he was, a lot of his, the things that he filed, papers that he filed, which were signed by his lawyer, but they were consistent throughout all the lawyers, so it appeared that he was drafting them, were very, very wordy and full of hyperbole.
In that same vein, the lawyers that represented him, have you litigated opposite them in the past?
I have.
The pleadings that they signed on Mr. Markel's behalf, are those consistent with the pleadings that you've seen them author in the past?
No, it appeared to me that Mr. Markel was drafting these pleadings because they just weren't drafted in a way you would draft them, and they didn't, again, make sense. They were internally inconsistent. For example,
Probably a lot.
moving
Probably
up
double
to
lawyer
the,
hours, that's for sure.
February timeframe, he was complaining about fraud by Wendi Adelson and not disclosing accounts as if that impacted the settlement. But then he said, very shortly or in the same near paragraph that he knew she had these accounts because he managed one of them. And he knew about the other account as well. So all he had to do was do third-party subpoenas to Schwab. He knew a Schwab account existed. That was easy. And so you can't say fraud. I made a decision without knowing. And then in the next paragraph said, but I knew these accounts existed. That's why I know she's committing fraud.
Okay. So in reviewing those particular motions, the one that he filed February of 2014, what was your opinion about the strength of that being granted?
Well, when
You
he
should record that, Dave.
filed a motion for enforcement at the end of October 31st, I believe, 2013, which complained about the $80,000 or so dollars. I think there was some question whether he paid $50,000 or $51,000 or $52,000. But anyway, he was essentially just around $80,000 underpaid. He hadn't paid his obligation. So she filed a motion at the end of October. Then there was no response, nothing. His lawyer withdrew. There was nothing in November. There was nothing in December. Then January 31st, so 3 months later, he filed a response that basically said, he didn't deny not paying, but he said her bad behavior, her unclean hands, give me a valid excuse for not paying her, essentially is what he said. And that is not legally, I don't think it was a very strong legal position.
Okay, and we'll come back. We'll come back to that.
Okay.
I want to back up to the June 21st hearing when relocation was denied. Did my client
We're gonna
in the
need
emails
video,
review
Dave.
appear to push back on Wendi and try to get her to do certain things?
Well, what I saw from what I was provided in the hearing, I think was on the 21st, and there was a couple of days, maybe the 23rd through 26th, something like that, where Donna Adelson, maybe the reality of the relocation had set in.
Have a
the
good
denial,
day.
and she was upset. So she was sending emails going like, how can we undo this? Is it possible to undo this? And then Wendi responded, I think at the end of that, Mom, I'm at peace.
It's a good one.
And then they dropped off. There was no more communication that I saw
And then
between them.
certainly after the July 31st final judgment, was there anything else where relocation was attempted or discussed?
Not that I saw.
Now, when you are representing clients, how do you handle the involvement of their parents or loved ones in your client's divorce?
If I know that they're very involved, I'll ask to meet with them and bring them in, because what I don't want is our third parties interfering with my advice, frankly. So if they misunderstand the law or they're giving advice to my client contrary to my advice, then I want to talk to them. I want to hear their point of view, and I want
Kind
to
of
give
has
them my
pointy
point of view.
ears.
And I find it's easier for my client to have everybody around them on the same page. So I just want to educate them. If it's a mediation and I feel like they're involved, I'll ask the other side if I can bring the mother or the brother, whatever, whoever it is, into the mediation, because if they're in the mediation process, then they see how it changes over the course of the day, because other facts might come in, other considerations might come in, because mediation is not just an opportunity to reach a resolution. You learn a lot of information out of mediation. So it's always helpful to have, if there's a family member who's very involved, it's helpful to have them there so they learn as you learn, and they understand how you reached an agreement, and then the litigant, the party, doesn't go home and have to explain what happened.
Do you have situations where clients, family members, or friends are offering advice and it's passed on to you?
Sure.
How do you address that?
I ask them to call me. Sometimes I say, if you don't trust my advice, maybe you should get a second opinion. And generally they don't. And I say, this is why I don't think that advice is valid or is going to help you. And we can have that dialogue. And if they're really strong about it, then I'll definitely ask to say, let me speak to your boss, your brother, your mother, so we can kind of talk through this, because I need them to understand my position and maybe theirs will change.
Now, you were provided with a number of emails that Wendi was sent by her mother. Did you see evidence that Wendi shared those with Kristen Adamson?
I saw no evidence that Wendi shared them.
Okay. And did you speak with Miss Adamson about that?
Yes.
Did she receive any of the input from Donna Adelson?
My understanding from Ms. Adamson is she really didn't understand that Donna Adelson was involved at all. I mean, she was there at that one hearing, but that's very common.
Did Wendi Adelson get the parenting plan that she was requesting in her settlement agreement?
She did. The entire marital settlement agreement was very beneficial for her from all the way through. She actually got a parenting plan that was more, I think it was more like 45, 55, something like that. It was instead of 7 days out of every 14 days, he was getting 6 days out of every 14 days, with 5 days and then 1 day in the off week. So it was split up a little bit, which was a typical parenting plan for that time period. So she got more parenting than she had really asked for. And that was to last 3 years. And then it went into 50-50. I think that got the youngest child to school maybe. So they did, until the youngest child went to school, she had about 55% parenting time. Child support, the division of childcare, that sort of thing.
And without going into too much detail, child support is a mathematical calculation.
It's a formula.
And it's based on a number of factors: income, childcare, insurance, health insurance, and parenting time.
Exactly,
Mhm.
exactly. And then Mr. Markel had asked for sole decision-making, for example, because he was upset if the children didn't eat kosher or whatever his complaints were. So he wanted sole decision-making, which is extremely difficult to do. The only time a parent gets sole decision-making is if the other parent is just incapable of making decisions, like drug addicted or seriously mentally ill, something like that. So that was really also telling that he was drafting that, because I don't know that either of the lawyers that filed on his behalf would have asked for sole decision making. That's just rarely granted. And so she got shared parental responsibility. He didn't get any superior decision making that he requested. He also requested for more than 50% of the marital assets, because he said he earned more and he created the assets more than she did, which is not a valid legal position. And she got what appeared to be equal value of assets
Of the marital estate.
of the marital estate, which was part of that 120,000 he was supposed to pay her.
Did Mr. Markel get the 50-50 time sharing he was requesting?
Not immediately. He had to wait 3 years for that. By agreement.
And
Thank
you
you, Dave, for the
mentioned,
super chat for M&Ms and
Keeping the
Skittles.
boys kosher.
We
Was
can evict
Wendi
Donna out of
Adelson
the house.
required that the boys keep kosher?
Thank you, Dave.
That I don't know.
Appreciate your
I
support.
think there were some issues about that.
In the marriage settlement agreement, was that required?
No,
Was she required in the marriage settlement agreement to allow Mr. Markel to come over to her home during her time sharing?
no. That would be extremely unusual.
In the marriage settlement agreement, was she required to have the boys available for video calls?
No,
Was Wendi Adelson, throughout the litigation, requesting that the boys be available nightly for her to speak with them when they were with their father?
no,
Was Mr. Markel granted every Jewish holiday?
no. I think he had requested that, but he was not. They alternated the Jewish holidays.
Was Wendi Adelson required to continue counseling with Mr. Markel and follow the advice of those counselors?
No, and that would be an improper order. The court can't delegate decision-making to a third party like a therapist. The court can't say, you need to go to your therapist and follow their advice.
Was Wendi Adelson required, pursuant to the settlement agreement, to equally split time on each of her children's birthday with Mr. Markel?
No, there was a general provision that each parent would get some time on birthdays, but there was no requirement that it be equal. And I really try to dissuade my clients from putting birthdays into agreements, because kids don't want to see the parents fight every birthday.
Mm-hmm.
Were either parties prevented from allowing the children to see anyone else unsupervised in the marriage settlement agreement?
No. I mean, the general premise was shared parental responsibility, which is what they have, meaning they have equal rights to get information, make decisions. The whole crux of that is you trust the other parent to make decisions that are healthy for your kids.
Now, pursuant to the marriage settlement agreement, was Mr. Markel ordered to pay both Wendi a lump sum and Kristen Adamson a lump sum?
Yes, he was ordered to pay $120,000 directly to Wendi Adelson and $10,000 towards attorney's fees to Kristen Adamson.
In what types of cases is one party ordered to pay or agree to pay part of the other party's attorney's fees?
I don't know.
Well,
At this
there's a
point, I don't know why we're
disparity
still here doing
between
this.
Assets and income. So it can be assets or income, or assets and income. I think in this situation, Mr. Markel's income was twice or so Wendy's, and his assets, from what I understand, including the non-marital assets, were more substantial than Ms. Adelson's.
Because I mean, if you want to think
In
Dan
your
is being the
opinion, was
asshole and
marriage
doing all
settlement
this,
agreement that was incorporated into
which
the
he
final
kind of
judgment
is,
favorable to
it
Wendi
gives them
Adelson?
even more reason to want to
Yes.
get rid of him because he's a headache.
Now, later,
So I don't know why
It was
we're doing
very
this.
fair. It was measured. I say that favorable only because he was asking for things that would have made it unfavorable and that were unusual requests. And at the end of the day, he gave up on those, and they got a very typical marital settlement agreement.
So from September of 2012 until the final judgment, July of 2013, as far as the litigation is concerned, it was not very contentious.
Not at all.
Now, after July 31st of 2013, did either side file any enforcement actions?
Just the 3 months later, the payments from Mr. Markel were due within 60 days. So that would have had them due at the end of September. And so, taking Kristen Adamson at face value that she tried to work this out during the month of October, on October 31st, she filed a motion for enforcement of the 100, well, what's left of the 120, 70-ish, plus the 10 for fees.
Okay. So Mr. Markel had 60 days to pay those amounts.
Correct.
And Ms. Adamson waited until 90 days after the agreement was entered, the judgment was rendered, and 30 days after the deadline, she
Correct.
waited to file.
She did. And even that was a pretty ordinary motion. It didn't ask for any drastic sanctions. It didn't ask for jail time, anything like that, which couldn't have been ordered. It would have just, she's looking for a judgment that she can execute on. So you have to get a formal civil judgment from the court, and then you can execute on that by attaching other assets or garnishing wages, that sort of thing. I've had the court open up and get retirement assets and kind of claw them back from the marital estate to make the person whole who doesn't get paid.
Okay. Now, in reviewing the emails between my client and her daughter after the relocation hearing, did you see any correspondence trying to encourage my client, I guess it was after July 31st, to encourage Wendi to do anything about relocation?
Not that I recall.
From your review of the emails and the pleadings, did it appear my client accepted that Wendi was going to be staying in Tallahassee?
Yes, it was done.
When you say it was done, what do you mean?
I mean, Wendi waived her right to appeal that by agreeing that the relocation would be dismissed. So
Now, prior to final judgment being entered, would Wendi have been able to attempt negotiating with Mr. Markel to try to get relocation, even though the judge denied it?
I can only imagine how the jury is right now.
Would there be anything
I'm ready to go to
wrong with
sleep.
Wendi or her family through Wendi offering some sort of financial incentive to Dan Markel to convince him to agree for her to relocate?
I see that all the time. I mean, I had a client pay $850,000 to somebody who didn't, to get her to not relocate. I've seen $35,000 to get whatever parenting plan you want, or to get less time.
Why does
depending
nobody
on
give
your
me money
financial
for things?
circumstances, that number can be wide ranging, but it's common. And in mediations, it's often common to see where the pain points are. If the pain point is money, then you use that pain point to get what you want on parenting. It's a negotiation. So that's routine.
Didn't even know
Nothing
that was an
unusual
option.
about that.
Routine.
Now, you testified earlier that you were provided text messages between Wendi Adelson and Dan Markel after the divorce was finalized.
Yes.
Although they didn't agree on everything, did it seem to you that it was amicable?
Yeah, I was only provided, I think, what the state provided to you, which was between maybe April of 2014 through June of 2014. So it was a few month period, even after these motions had been filed that kind of upped the temperature a little bit, and they were working well. I saw some communications where Mr. Markel was inviting her to join him in the Boys for Ice Cream. I know that there were many occasions where he was traveling and his travel plans adjusted, and she adjusted exchange times based on his travel. I think he did the same for her. They were swapping days. It was actually much more amicable than many cases I see. They were very flexible with each other.
Now, you indicated earlier that October 31st, 2013, Kristen Adamson filed a motion for enforcement.
Correct.
Now, you mentioned a motion for enforcement and contempt. What is contempt?
Well, in this context, I think that's just the title of her motion, because in the body of the motion, she didn't ask the court, I don't believe, to find him in contempt of court. She was just looking for a judgment so she could execute on the judgment and collect her money.
So although the motion itself may have been entitled contempt, enforcement and contempt, the prayer for relief didn't include any request that the court find him in contempt?
I don't recall seeing that at all. I think the court said, make him pay, ask the court to make him pay. And what that means is give me a judgment so I can enforce on that judgment, however that may be. It's just a collections issue.
You indicated that you don't think it was there. It would be helpful to see the pleading itself.
Sure.
May I approach the witness?
To be honest, none of us care about this. We just want to see Donna be on the stand. This is annoying.
Specifically, page 338.
The family, it's disgusting. They're usually close, but there are some judges who like put custody streams like on YouTube. It's awful. It's awful.
Is that the October 31st, 2013 motion that Ms. Adamson filed?
It is.
Parents usually act more like children than the children do.
Body of the motion, does
Sad.
it seek anything concerning contempt?
In the body, which does not control the ask of the court, which is called a wherefore clause. And under the wherefore clause is where you say what you want the court to do. Above the wherefore clause, it sets out the facts. He was required to do this. It was due by here. Here's what he's done.
I don't see
Here's
the
what he owes.
relevance to all of this.
She's incurred attorney's fees. And then she says attorney's fees pursuant to this agreement are a form of support. The former husband should be required to show cause why he should not be held in contempt for failing to pay a form of support. So that's accurate in the sense that the money owed to Wendi is not enforceable by contempt. The $10,000 fees can be enforceable by contempt. So she says that above the line, but then the wherefore, what she asked the court to do is enforce the marital settlement agreement, require him to immediately transfer to the former wife the remaining amount due to her pursuant to the marital settlement agreement, together with statutory interest on the same, order him to immediately pay the wife's attorney's fees of $10,000 and award her attorney's fees for this action. So all she's asking, she's not asking the court to hold him in contempt here. She's just asking the court to order him to pay it immediately. And the sanction for him
Totally,
being
Dave.
required to pay the attorney's fees to Kristen for having to file this motion, and he'd be required to pay statutory interest on the unpaid amounts from the date it was due until the date it's paid. So that's his full exposure.
Oh, I need to do mine too, girl. Maybe I'll do them this afternoon. I think I'm going to go with pink nails this week. Oh, yes. We'll see. Either do them today or tomorrow.
Never the wrong decision with pink.
I'm going to use the sparkle one you sent me to. I haven't used that one yet. I've only done just the
Yay.
pink. So I'll probably do that.
I bought some pink iridescent I'm going to try.
In the
Ooh.
scheme of this dissolution and the circumstances of this case, was the amount of money that Ms. Adelson was seeking through this enforcement motion an enormous amount?
I didn't view it that way. I viewed it as kind of an annoyance that she had to go through these hoops to get the money because he had the money and he owed the money. But it
I mean,
wasn't
it's
going
a
to
large
be
amount of money.
Did you believe, is
Some
your
people-
opinion that that motion for enforcement that was filed on October 31st, 2013 had merit?
Absolutely.
And what were the possible repercussions to Mr. Markel?
He would have
Nice.
to pay more. He'd have to pay more in fees and more in statutory interest and more to his lawyer to fight it. That was
Happy Bunny.
Were you provided with a series of emails in
Happy birthday to Mr.
mid-December
Laney.
of 2013, where Mr. Markel emailed the parenting coordinator and Wendi Adelson complaining about a host of issues?
I did.
Okay. Was one of those issues one where the boys allegedly said that grandma referred to him as stupid?
Yes, he brought that complaint up to the parenting coordinator and to Wendi in the same email in December 18th, maybe, of 2013.
From your review of that correspondence, what did he want to happen?
My recollection is he was asking Wendi to be mindful of that and to be alert and make sure it didn't happen.
Did he ask that my client not be around the children unsupervised?
Donna Adelson, no, he did not.
Super
Bunny.
According to what you reviewed, when did those
His name's now Bunny.
quote,
Sorry,
stupid events allegedly occur?
According to the email, he said there were 2 or 3 occasions in November where the kids said something like, "Grandma thinks you're stupid," or something like
I
that.
love that.
Did Mr. Markel file any action, any motions or supplemental petitions in November or December of 2013?
Related to that allegation?
Yes.
No.
Now, the motion
Oh.
for enforcement filed October 31st, when was that set for hearing?
It was initially set for hearing in February, and I believe that was set in December, and it was
Autocorrect. The
the
gift that keeps on
certificate of service,
giving.
which is the bottom of the motion. You file a certificate that says where you have sent this document to whom.
All right, you guys, I got to step out
And
because
it
I have
went
my
to
appointment.
Mr.
The
Adelson's
lovely
suite,
Terry here is going to
in December.
take
Mr.
care of you
Markel.
all.
I'm sorry, Mr. Markel's.
I'm
meeting.
in
And,
control.
Yeah, so
And
there will be a
then
separate afternoon
nothing
stream for
happened.
this, by the way, guys.
All of
And
January
I will
went,
see you
nothing was
all
filed.
for
And then
that
the end of
one
January,
10
which
minutes,
at this
5
point
minutes
is 3 months
before
after the motion was filed,
they come back from lunch,
um,
whatever that
a
means. So
response was filed.
I will
And then
see you
the
guys later.
response
Bye. Thank you, Terry.
basically said, yes, I owe the money, but I don't have to pay it because Wendi had these other financial violations. And then she referred to.
No, the
child
jury wants a
about
nap
a retirement
from this.
fund. And then 2 weeks later, I think it's February 14th, he filed a motion for contempt against Wendi. In that February 14th, it was kind of a companion document to the January 31st response. Again,
It's like
he
tit
would
for tat,
do
people.
multiple
Let's just
filings on
move
the same
on.
issues. He again just addressed, but a little more vehemently, the allegations of financial fraud. It was only a financially focused document.
What defense did he claim to have to avoid paying Wendi Adelson as he'd been ordered?
My recollection is his defense was that she did not put on her financial affidavit a certain non-marital asset, but he knew that an asset existed, but it was fraud. It was kind of circular. And there was, he said he didn't have a updated document at the time of the marital settlement agreement or something like that, to know what the then value was. But those are all pre-divorce issues. So he had ample.
This tells me the
opportunity
defense
during
doesn't
the
have a
divorce to
defense,
do
so they are
third-party
trying
subpoenas
anything.
or motions to compel or other ways to get those documents. And then, according to Chris, all of those were dealt with in the marital settlement agreement anyway, and I don't have any reason to doubt that. But yeah, he was just trying to say one good breach deserves another or something like that, and it wasn't legally supportable.
That's not a valid defense.
Pardon?
That's not a valid defense.
I wouldn't make that defense, no.
Now, if a party in an action believes that there has been fraud in the underlying, securing the underlying agreement, is there a way in which they can contest that?
There is. If you're alleging fraud, and if it's fraud in the financial affidavit, you don't even have to do it within the first year. But there's a rule that Ms. Adamson referred to. It's called 12.540, and that's where you can move to set aside the marital settlement agreement based on fraud. So if you
I
find
agree,
out
Sammy.
later
I
that
Don't
they had
see
won the
this.
lottery before you and didn't disclose, or that they had some stash of gold bars somewhere or whatever, you can come back in and say they didn't disclose that. But it has to be material. And so the case law is pretty clear that the fraud has to be an actual fraud that impacted the agreement. For example, I think there's one case that talks about maybe there was a minor $3,000 to $5,000 tiny IRA or something like that that was never disclosed. They just had forgotten about it. It was very small in relation to the rest of the assets. And the court said that didn't really impact anything, that we're not going to set aside an agreement based upon that.
In other words, it's a high hurdle.
Sure, and it had to
overcome.
have impacted you. In this instance, it was clear
Oh,
from
that
Mr.
woman.
Markel's own motions, he knew about these assets. So I think his fraud allegation was completely baseless.
Now,
Yes,
in some
Llama
of
had an
his
appointment.
emails
She'll be
and-
back.
and
So you're stuck with
filings,
me,
he was
Terry.
asking for 100% time sharing,
She's coming back though.
more
You don't have to keep me
restrictions,
forever.
more access to the kids. Did he ever present a proper pleading to the court to try to get those things?
No. What happened was he did the January 31st response, and then he did the motion against Wendi on the financial issues February 14th. And then towards the very end of March 26th, after Kristen had filed a motion to dismiss his fraud motion as being a sham pleading, essentially, I guess he kind of ramped it up a little bit. So he filed a motion complaining about parenting. And it had maybe 10 different points. It was very long. Each point was maybe a page long of different paragraphs. And in that motion, almost all of the related violations were not violations at all. There were no court orders requiring her to do what he wanted her to do. So he wanted a certain number of video calls, and she didn't give him enough video calls. Well, video calls weren't required. He asked for a certain number of phone calls, and a number of phone calls wasn't required. He was asking for,
I agree,
there
Dave.
was
This
some
doesn't have to
right
do
of
with the price
first
of tea in China.
refusal. He didn't like that when Wendy's parents would come to town, that she would maybe go have dinner with friends and let them spend time with the kids. Or she would let them stay home from school so her parents could spend time with them when they were little babies.
So they fought a
And,
lot of
he
custody
didn't like
issues.
that
They're
because
two
he wanted to
attorneys.
be able to
They went
give
back and
some
forth.
childcare
Move on.
during her parenting time so he could see them every day. And I think the child care person had asked him
Well, he
probably
needs
not
to
to do that, but he
in my
wanted to do that. And he wanted her to go to like a therapist and follow the therapist's advice on basically doing what he wanted her to do. So it was a lot of noise trying to enforce something that wasn't a provision to enforce. There was no underlying court order to enforce.
It's lunchtime. Why do they need to
Is
stop?
that the pleading that Ms. Adamson filed a motion to dismiss about?
That may have been, I was thinking she filed it against the February 14th, but I could look at my notes and clarify if you'd like me.
If it would be helpful.
It would be helpful.
Oh my. Guys, I really do not know what this has to do with the defense. This is custody issues. A lot of people go through custody issues and
Yes.
agrees to stuff
Um,
and then they don't do it. What's the
Yes, it looks like on April 11th. Nope, that's his response. Let's see.
I know she's
Yes,
not.
it was before the,
She's
it was,
not.
my recollection was correct. She filed the motion to dismiss on March 10th to dismiss the motion regarding the fraud.
I
That
bet he is
alleged on
rolling his
February
eyes in his
14th.
head.
And then I think as a response to that motion to dismiss, then he kind of amped it up with this motion to enforce that dealt with the parenting issues.
And the motion to enforce that dealt with the parenting issues, is that the March 26, 2014
Exactly.
motion?
Correct. And then that was all set for hearing for May 15th.
Okay. The complaints that he raised in the March 26, 2014 motion, you indicated there were things that he was asking for that hadn't been ordered. And are you referring back to the marriage settlement agreement? There were conditions that he wanted that weren't actually in there?
Right. He was trying to enforce his view of what this post-divorce parenting should look like. But there was no court order that required her to make the children available to him during her parenting time. I think one of the complaints was he wanted one-on-one time with the kids, and she should be ordered to let him take the kids during her parenting time one-on-one.
Hi, Kathy.
There was a couple of
You're
different
missing a lot of
provisions about
boring custody
communication.
stuff.
I think like the 8th point he made, well into this very long motion, was he brought up the stupid allegation from November, and this was the end of March. So I didn't see anything in his allegations that had any recent problems with him being disparaged or by anybody calling him any names. So he mentioned that. I think it was his 8th of 10 points in that motion.
Was it in that pleading that he was asking for sole decision-making authority?
Yeah, I believe it was.
Would there have been a basis for the court to grant that?
No,
Thank
no,
you,
he would
Lady
have had to
Ingrid.
go through that supplemental petition that we talked about earlier, where he would have had to show material and substantial change in circumstances and that it was in the best interest. And there's no indication he would have been successful there. And he didn't plead it correctly anyway.
Now, with respect to the complaint about my client allegedly saying that she hated Dan Markel or she called him stupid, was that allegation a feature of his motion?
No, it was buried, like I said, 8 points down, 8, 10, 12 pages down.
Just a few paragraphs of his motion?
Yes, it
Yeah,
is.
3
Motion. It
paragraphs.
is painful.
Was there any indication that those claims were true?
No, and I don't think he could have proven that because he's talking about what purportedly a 4-year-old may have said to him. And
Why
I
are
think
we
even in
talking
his
about what
motion,
he could
says, "I
prove?
don't know
What
if
does that
this
have
is
to
true
do with
or
him being
not.
murdered?
I don't know if Wendi was
Please,
present
somebody
or
help me
not,
out here because
but
I'm
I
about
would like
to
Wendi
just lose
to
my
stop
crap.
if it's true.
Did the grant this motion, the March 26, 2014 motion that the state has called the grandmother motion, did that request that my client not be permitted time with the children?
No,
Did Mr. Markel request that my client's time with the children be restricted?
the only thing he requested, and he had the first right of refusal, maybe point
Dave,
4
I'm
or
considering
5, and
midday
then he kind of
drink as well.
tied in this grandparent thing on point 8. But what he appeared to be upset about mainly was when she came to visit and they kept the children home from school, that he couldn't go visit the children at school. So he didn't want her having unsupervised time as it related to the first right of refusal. He wanted the kids to go to school and not be left alone with the grandmother because he wanted to see them. The same thing with the evenings. If she went out to dinner because her mom was in town and it gave her a chance to run out and see a friend or something, he wanted Wendi to have to call him so he could watch the kids, even though mom's there to watch
It's
them.
called first right of
which
refusal. It's very
That's not
common.
the purpose of a first right of refusal.
I was just about to ask that. What is the purpose of that?
Well, the purpose is if a parent is unavailable and can't provide care for a child, then you offer the other parent the first right to take care of the child. It's not if my rule, or what I tell my clients is if you can't make it to the hospital, if you can't meet the ambulance at the hospital, it's a first right of refusal. You need to have a parent available who can take care of any emergency. It's not to prevent the kids from having sleepovers or spending nights with grandma or, anything like that. That's a normal part of a kid's upbringing. And so you don't want them to never be able to spend the night with grandma or never be able to go to a friend's house.
Unless
because
grandma's
they
a
happen to be in
murderer.
Divorced family. Those are just
Just
decisions
saying.
each parent makes within their own household. So a first right of refusal typically is triggered when the other parent is unavailable, out of town, that sort of thing.
Okay. Now,
No.
have you ever seen a scenario where a court prohibited a grandparent from having unsupervised time with their grandchild?
Only in one occasion I can think of, and he was a convicted child molester.
Nope. I can attest to one time here
What
in
is your
Texas when I was an
opinion
advocate.
about the persuasiveness of the March 26, 2014 motion that Mr. Markel filed?
I think it would have been similar to what Ms. Adelson described, the judge saying in the middle of the relocation hearing, which is, don't file things like this. I don't think it would have been well taken by the judge at all, because it was a complete waste of everyone's time and money and emotion, because it was baseless. It didn't tie to anything.
Now, even if his allegations have been true, would the court have been permitted to modify the terms of the marriage settlement agreement based on his filings?
No.
Why?
You have to do a supplemental petition if you want to modify terms of the marital settlement agreement. You can enforce terms, but you can't modify.
Agreed,
terms.
lady in gray, but I can
In
test
reading
one.
the motion,
I agree. Motion to screen.
does it
I
appear to
agree.
be intimidating?
No, I think when I was making notes, I put insert by role here. You know, it was a lot of words, and he was obviously wanting life to look like what he wanted it to look like, but that wasn't reality. So it's just a matter of breaking down each allegation and addressing them.
Should Wendi Adelson or my client Donna Adelson have felt threatened, or would they have felt threatened based on that motion?
They shouldn't have. And
They were
that's one of
irritated.
the reasons I wanted to call Kristen, because again, when I read that motion, I was kind of taken aback that a lawyer would have signed that and allowed that to be filed. And I thought it was kind of nonsense. And I wanted to get Kristen's take on that and see if she agreed. And she did. And she said that she had advised Wendi of that. And that's what I would have expected from her.
In the emails or text messages that you reviewed, did you see any communication with that indicated that my client Donna Adelson was aware of that March 26, 2014 motion?
No, not in what I was provided. I saw early during the divorce period that Wendi had sent her mom a couple of documents. I know the petition for relocation that Donna helped make suggestions to beef up the facts, which I thought were pretty helpful suggestions, because like Ms. Adelson said, relocation is extremely difficult and you really have to have as many facts as you can to support yourself. So I saw that there was some editing and some input on that petition. But after the divorce, I didn't see any communication about sending pleadings. I don't even know that I saw any reaction from the financial motion, but certainly not from, I saw nothing communicate, either that she communicated the motion to her mother or that her mother reacted to it in any way. I didn't see any responses.
Would Mr. Markel been able to sustain his burden of proof for that motion?
I'm sorry, say that again.
Would Mr.
does it
Markel have
matter
been able to
what
sustain
Mr.
his
Markel
burden of
could do?
proof for that motion?
No, I don't think so at all. You know, if you're talking specifically about like point 8 about calling him stupid, his only evidence is a 4-year-old child. Otherwise, it's hearsay. And I don't think a judge is going to talk to a 4-year-old child about whether their grandma thinks their dad's stupid. It's just, there's so much worse that goes on. That's not significant.
In your experience, what do judges typically do when this type of allegation is raised?
My experience is the judge tells everybody to behave themselves and sends them on their way.
So we've talked about this not being a hotly contested case or a high conflict case. How many pages are in the court file?
Hey, Mama Llama.
There's roughly 570. And again, a lot of those pages are kind of repetitive documents filed by Mr. Markel that might say the same thing. Like he'll do a motion, then he'll do a memorandum that says the same thing, then he may do a response that says the same thing, or in different orders. So 570 though.
Do you know how much in attorney's fees Wendi Adelson incurred, attorney's fees and costs
Why does it matter?
for the dissolution of marriage and the enforcement proceedings that began afterwards?
I only know what Ms. Adelson said, which is around $30,000.
Now, in your career, have you worked true high conflict custody cases?
I have.
in particular, do any come to mind that involved an attempt to seek relocation?
Yes, I had a particularly conflictual relocation case that started in 2018 and went through 2021.
So about 3 years.
Yes, including an appeal.
May I show the witness the demonstrative?
You may.
Okay, it's a box with a lot of files. I do not get this witness and this line of questioning, to be honest, guys. I don't know. It sounds like a very common custody battle case to me.
Volume 1,
I don't know, Kelly. I wonder too.
2, Volume 3, Volume 4,
Oh, he can count. That's 4 binders.
Volume 5.
5.
Question for the witness.
Do you recognize this file?
Yes, I think I forwarded this to you.
This are these 10 volumes.
I agree. That's what they're
Example of
thinking, motion,
like,
but
hotly
you don't
contested
murder a
location.
child's parents because you don't
Well,
get your
and
way.
I just count 500 pages per binder. So that looks to be about 5,000 pages.
Me
I think the
too,
actual
Dave.
tables were over
Me
10,000, so this doesn't appear to be all of it.
Okay.
And there were 2 volumes on the record on appeal, so perhaps only one of those volumes got.
I don't
So
see the relevance.
The clerk's file in the case that we're referring to as the demonstrative is twice as big as what we have in front of us.
I think the jury is
Yes,
sitting there
based
going,
on just
yep,
assuming 500 pages per notebook.
makes her look more guilty because this is not a defense, in my opinion. I don't know what the jury's thinking, but if I was in the jury, I would think in that. Uh-oh, Savage, are you flirting with
Can you
Mama
tell
Llama?
the jury what the issues were in that case?
Gosh, Judge, what's the relevance? Object.
Sustained.
Judge, may we approach?
No.
Judge, we're entitled to make a record. I believe I have the,
Members of the jury, the bailiff will take you to the jury room.
Oh boy, here we go. This is insanity, in my opinion. Oh, I just want to slap her. I wish they wouldn't show her to me. Oh, let's see what he has to say. And I'm about to sneeze. Okay, don't sneeze, Terry.
You may be seated. The relocation issues within this case are certainly relevant as to a separate other case. What is the argument that you're seeking to make for the record?
Your Honor, the relevance of this proceeding is the witnesses identified this as a hotly contested custody and relocation matter. I think we're entitled to have her explain what the issues were, what was involved in litigating that, as well as the amount of her fees that were incurred and the expenses that were incurred, so that we can make the comparison to the case that involved Wendi Adelson and Mr. Dan Markel.
Kappelman, any other argument on this issue?
It's relevant, Your Honor.
As to the point on relevance, the court's ruling remains the same as to issues of relevance. Again, the relocation that is disputed within this case as it relates to the divorce file certainly is an issue. As to any other case files, this witness may testify concerning her experience, but we're not going to go through this case file in its entirety. Please bring back in the jurors.
Your Honor, that was not my intent to go through the case file in its entirety.
So what? Somebody else has twice as
Mr.
much
Bailey, please
files.
step down, step out of the the courtroom doors. If you can radio Deputy Bunk to leave the jurors in the room, please approach.
I mean, why are we trying to say that this couple had it worse and nobody died? So why would this smaller case cause that? I mean, I guess that's what I'm thinking he's saying. And that makes absolutely no sense to me because every case is different. And somebody who had half of what Adelson had could still want the other party dead. So I don't know. That's just me. But you can't compare apples and oranges and come up with a banana. And there is no such thing as apples to apples in custody cases. See, y'all are sitting here going, God, where is Llama? She doesn't use fruit things. Okay, Dave, you got my fruit thing. Okay, good.
Gesturing, do not make any comments, do not make any expressions in front of the jury in any way that would be intended to inappropriately influence them. The jurors using the restroom. Please use the restroom or stretch your legs if you need to. We will continue with the witness after that.
I wonder why he doesn't just call lunch. But this just more and more tells me they don't have a defense. They're trying to say that, oh, other people have had it worse and they didn't go and kill somebody. So why would anybody think that just because of these few things that Donna would want her son-in-law dead? Guys, exactly, Lady in Gray. Another case isn't relevant. Donna is more controlling and more involved in her kid's life than maybe the other grandparents or family members. So I don't see how it matters. And it tells me if this is the defense's strategy and what they have is their defense, it's very lacking, in my opinion, because people have planned murders over a lot less than custody issues. So I think it comes down to control. I mean, Donna wanted her way. Oh, I'm sorry. This is just infuriating. To me, this is a waste of the jury's time. Anybody else think that? The jury has got to be sitting there going, I am not in family court. Why am I having to hear line by line, petition and date for all of these motions filed? I do think, in my opinion, that it gives more to the prosecution. And you are just showing their case more because, we've already heard, how much Donna was controlling and involved in her kids' lives. The jury's got to be sitting there going, yep, that pissed off Mama. Yep, Mama didn't like that. Don't know if you knew this, but lunch will be a little longer today so that Donna and her defense can talk about her testifying. She better get on that stand. I am just saying she better get on that stand or I am going to feel like I have been robbed because I've been waiting for it. I've been anticipating it and I need it. So she better get her butt on the stand. Okay? Now, am I going to say if I was her attorney? I would not put that lady on the stand. I would not if I was her attorney. Dave says, and this is why I would never make it on a jury. I am way too vocal. I'd be pissed and they'd know about it. Yeah. When I sat on that jury, it was hard, especially knowing that my face shows everything. I had to literally look at the floor to try to keep people from knowing what I was thinking. But I think her attorneys, if they're smart, they're trying to talk her out of getting on the stand. But I also, I totally agree, Lainey. I think she's screwed if she does. But I also think Donna is narcissistic enough. She is going to tell her attorneys, I am paying you, and this is your job to do what I want. Okay. Maybe I'm immolating Donna, but I could just see her saying that. I could so see her telling that. And sometimes, guys, if you ever have to hire an attorney for something, you should listen to them. Okay. I'm just going to say you should listen to them. They're the professional, they're the subject matter expert because you're not. And they are there to also protect you from yourself. Okay. But for all of our sake, I hope she gets on the stand. She needs to get on the stand because we've waited a long time for this. Okay. If she doesn't get on the stand, I'm going to have to write her a letter and ask her if I can come and visit her in prison since my son Jeff is moving to Florida. I'll need to go and sit with her. So I'm going to tell her, I want to know what you would have said on the stand. And I am more than happy to role play. Okay. No, we are on break because a juror was still in the restroom, probably taking a nap, hiding out. So he said the others could go to the restroom. But yeah, I'm going to tell y'all right now, if she doesn't get on the stand, I will be drafting a letter to send to her, and I will be reaching out to her attorney, and I will share all of that with you. But yes, I will be willing to role play with her because as controlling as I think she is going to need to get that out. So I will offer to role play with her so that she can say what she wanted to say on the stand. But I will even tell her, hey, I will write out questions for like cross examination. You will tell me your side, however you want to go, say what you want to say, but I get to cross examine you. I would love to have a film crew ready to go, but not Dateline. Don't have that kind of money. And they probably wouldn't let it in. But then it is Florida. Florida's a little bit more lenient. That's a good idea, Dave. Good idea. Maybe I could talk my son or my son-in-law to being my camera crew member. Who knows? But I think she needs to tell her side of the story because she can't. If she doesn't get on the stand, she's not going to get to tell her side. I am willing to do that. I will take one for the team. I could have Llama film it too. I know, but the side eyes and the eye rolls with me and Mama both. Oh Lord, I don't think Donna could handle the both of us. But it will surprise me if the defense attorneys can convince her to stay off the stand. I mean, I've seen miracles happen. I've seen it happen, but that would surprise me. She got to think this is her last chance to tell her side of the story. Lady and Grace, she will have an appeal to worry about, but depending on that appeal, I would be willing to maybe we could work something out with the attorney and hold part of it until after her appeal is decided on. Maybe. I mean, I am willing to think outside of the box and be creative. I am willing to do that because I feel it is my civic duty to give all of us who have spent all of this time watching this the satisfaction of hearing Donna's side of the story. Because, guys, I think she's got a lot to say. I do think it would be an appeal problem because I do think she would say something she shouldn't say. But I am willing to take one for the team and give it a try. See, Dave, I'm glad you like to think outside of the box too. I mean, heck, maybe I could even agree to get her, if I paid for the phone call, we could do a jail phone call. And then I could record the audio. Maybe we could do that because I need to know what Donna has to say because I'm telling you, the lady, Linda Bailey, who's been on the stand this whole time, she has given me nothing except making me glad that my kids are grown and I am no longer in custody disputes. See, I agree, motion. I agree. I'm going to do it. I'm going to do it because I will also, I mean, I'm a grandmother. I can relate to that. I know what it was like when my grandson was taken for a year and we didn't know where he was. I never wanted his mother killed for that, but I can relate to a grandmother not being able to see her grandkids. So I can relate. Yeah, Donna, bless your heart. Guys, I want to know how many of you think that after she's convicted that Harvey will divorce her? Do you think he will divorce her? Do you? Because I kind of think he will. But because once he's out from under her thumb, I think he was a kept man as far as he did what she was told or what he was told. I think he was scared of her. I wonder once she's convicted, will he do that? And part of the divorce settlement will be money to pay for her appeals and things. See, I mean, I want to know. I want to know. Okay. Oops. Sorry, guys. I just hit myself. Yes, he's a cat. He was a scared man. I mean, she ruled the roost. Let's just be honest. She ruled the roost. Ooh, I wonder if I could get any of her prison daughters to talk.
Continue with your examination.
My brain is just working. Okay, lady, become relevant.
Ms.
Please.
Bailey, how did the Adelson Markel divorce compare across the variety of cases that you've handled?
Simply, it was routine, it was amicable. I've done similar cases that have had anything from 2-day to 7-day trials. I've
Oh,
had them range from
good point.
$200,000 to $500,000 in fees and costs.
Good
I've had
point.
multiple financial experts, child development experts, vocational experts, all retained, deposed, testifying. I've had cases with multiple discovery issues, discovery over psychological records, financial records, third-party subpoenas, 2 full days of deposition of just one party. This was an easy case compared to many.
Did it look worse than it was because of the way in which Mr. Markel's pleadings were drafted?
Yeah, I mean, he drafted pleadings, motions, I think responses would be more appropriate than pleadings, but that's kind of technical. He
Wonder if Harvey
drafted
would
them
talk
like he
to
was
me.
drafting a law review article or something. They weren't technically correct. They were verbose, they were hyperbolic.
Don't
He
talk
used
ill
a
of
lot
the
of
dead's
inflammatory
pleadings.
language.
That's rude.
But when you really looked closely at his requests of the court, there was no there. There was no foundation for his asks.
Nothing further, Your Honor.
Cross-exam.
Thank God.
What is it you were asked to do in this case?
I was asked to review the documents I was given and to opine about whether this was truly a highly contentious custody case, essentially.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce,
Exactly.
right?
I don't know how many
Unique
they have.
experience.
So isn't
Sure.
the contentiousness in the eye of the beholder, in the sense that
Yes.
to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide
Yes.
world. Do you
Well, that's
agree
one
with
reason-
that?
Yeah.
Do you agree with
Ms.
that?
Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case as a lawyer might be routine, whereas to the parties it's the most important thing in the world?
Mhm.
To some degree, that's one reason I called Kristen, is Miss Adamson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm. And I find that when I litigate against her, we reach resolutions that people
She's got
stay
it hot, and I love it.
measured and calm, and we get things done.
Don't know why I whisper.
She's not one of the other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers is to explain to our clients when we get emotion. If I get something, for example, that, although I've never had something similar to what Mr. Markel would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy. But there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to Wendi.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but
Do they ever get upset about the gibberish in the pleadings?
Thank you,
the
motion.
offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
I would say annoying more than emotionally charged.
No,
You
it's
would not
emotionally
say that
charged.
Divorce and child custody issues are emotionally charged.
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000
you're
pages in
not-
front of me.
You're not in the mind of the people that whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder,
Right.
is it?
It's emotions, it's feelings.
That's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
So,
Not what
like,
she asked.
I may think I've got a bag of stinky garbage, but the garbage man might not
Motion,
think
I
it's stinky
agree.
at all. Do you get the reference?
I don't.
You don't.
What is no big deal to us is a big deal to these litigants, right? You can't agree with that.
Perhaps.
You can't agree with it. Strike the question. You were asked, let me ask you this. Let's go on to something else.
Jeez. Hi, Buffy.
Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law
I've
litigation?
never had anyone murdered. I had in one instance, a Middle Eastern person committed suicide just because there was a divorce, and that was shameful. So nothing was it was literally the day after the petition was filed, and he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you,
Yep.
divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
Not according to me, but I didn't grow up in Iran or wherever this custom or feeling.
Exactly, Ms. Bailey. To
Derived.
that person, it was a reason to commit suicide, right?
Apparently so.
Aren't these issues raised in these pleadings potential fuel to make people upset?
Potential fuel to possibly make people upset.
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal. It wouldn't be granted. It was buried in there. But the allegation is grandma is disparaging me to these kids and I won't tolerate it, right? Couldn't that be upsetting to grandma?
That would piss off Grandma Donna.
Exactly.
It would.
It shouldn't have been. There was no proof,
It shouldn't have. Who
It
are you to
shouldn't have been,
say?
in your opinion.
in my opinion.
But in your opinion,
Jeez.
divorce is no reason to commit suicide, right?
True.
Get him, Georgia. Go.
Gibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No, it's probably not flattering, but I've seen far, far worse.
You've
We're not-
seen worse.
I have.
But have they?
If Mr. Markel wasn't paying by the deadline, isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Miss Bailey?
It depends on who you are.
Exactly.
Oh, that's
So we
true.
have to ask the parties, right? Right?
Sure.
Okay.
Yeah, I think on that issue, he clearly had the
Dave,
asset.
I have
at the end
so
of the
much
day,
to
he wasn't
say.
gonna pay. It was just a matter of jumping through hoops to get the money.
He was either going to pay or he was going to get sanctioned by the court or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail. But
Well, you sat in the courtroom during Ms. Adamson's testimony,
I did.
didn't you?
I
And Ms.
did.
Adamson said that that was one alternative, an extreme alternative, obviously, but that's what contempt means, right?
But that would-
Ultimately.
wouldn't even come into play until the motion for enforcement, and then he didn't abide by that, and then the judge asked him to do something else.
It's
and then he
still
didn't abide by
emotional.
that. But I think jail was pretty far-fetched.
Well, as long as he pays. Ultimately, the teeth is you go to jail.
No, that's not true.
It's not true. Okay.
Um,
Ms.
Me
Adamson
too,
was
Kelly
incorrect
P.
on that
Me
point, I
too.
guess.
Objection, Your Honor, that question that we just strike.
I'll
What is
rephrase
the-
it.
what is
Was
the objection again?
It's an improper comment on the witness's testimony.
Savage, I
Say
agree.
again, please rephrase
This-
the question.
I said Ms. Adamson was incorrect on that point when she said jail was a potential option. Is that correct?
Well, I could break it down. There's two different matters in that financial motion on October 31st. One was the $70,000 still due to Wendi. Jail is not a possibility on that, but you don't send people to jail for failure to pay money. We don't do that. The $10,000 in fees to Kristen was more debatable because that could have been in the specter of support. And if you don't pay alimony or child support after repeated chances, I guess you could say, jail might be an option, but there's always a purge to that. So I've seen many times in child support, if you don't pay child support, then the judge says, bailiff, get, Mr. So-and-so or whatever. And then all of a sudden he comes up with money out of his pocket and he pays, he never goes to jail. So you always have the key to the jail when you owe a support obligation. So technically, if he wanted to go to jail rather than pay Kristen the $10,000, eventually there may have been a hearing where that happened.
But it was far off, I bet.
I've seen one person in my career go to jail over child support.
Right. Because
Exactly,
they pay
Kelly.
because they don't want to go to jail. If there was no jail and no consequences, they would never pay. Right?
Some people wouldn't. And that's just support. There's no jail consequence to the $70,000 to Wendi. It was only the $10,000 to Kristen that could have possibly remotely been a possibility.
Did
Slap her.
you see evidence in this case of Wendi taking her mother's suggestions, cutting and pasting them into an email as her own, and then forwarding those questions to Ms. Adamson?
No, I didn't see any.
And did you see in your review of the evidence in this case, Ms. Adamson responding to those questions and Wendi then forwarding those answers to her mother?
I don't recall that. I don't recall saying that.
Did you review the communications from Donna Adelson, both in the form of email and text messages, that suggest that she was in fact extremely disappointed and upset about the outcome of the relocation motion.
I did in probably the 5 days after the relocation, which was say 4 weeks before the ultimate settlement in July. There were a flurry of emails where she was obviously upset.
Did you review Mrs. Adelson's communications after July 31st that's suggest she's
What's the blue
consistently
thing
still
behind
upset
Donna,
about this?
guys?
I wasn't provided.
So you
Any-
were, I'm sorry, finish your answer. You weren't provided any?
I wasn't provided after the flurry, right after the relocation, before the final judgment was entered in July of 2013. After July 2013, I don't recall seeing any emails from Miss Donna Adelson about relocation.
Did you see any emails from her at all post settlement?
Not until maybe December. It was a while. October maybe.
Okay.
Several months.
If Dan Markel had agreed to the relocation post denial, post stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All right. And if he was murdered, it could happen, right?
It's the turtle cage. Oh my God, you guys are great.
So you categorized Dan Markel's pleadings in a lot of different ways: baseless, untrue, unenforceable, gibberish, nonsense, suggestion of unethical filings on the part of his lawyer to sign off on them. Are you saying, I think what you're saying is that those things wouldn't amount to much in court because it's not really effective filings. Is that what you're saying?
What I'm saying is his motions post July 31st were not based in the law. And I don't think that allegations about accounts he knew of not being on an early filed financial affidavit would amount to fraud. And it certainly wouldn't excuse him not paying what he was supposed to pay under the terms of the court order. And the motions related, the motion in March 26th related to parenting, he was trying to enforce things that weren't in the marital settlement agreement. There was no court order to make her do the things he wanted her to do. So there's no basis for the court to have granted his motion.
Right. So they weren't going to be successful. It's your opinion they weren't going to be successful.
Yes, that's my opinion.
But would you agree that the things he was putting in there are inflammatory?
I would agree that they were inflammatory.
And they potentially could make the parties or their relatives upset to read those pleadings and those inflammatory accusations.
Sure, nobody wants to read those allegations, true or not, about themselves in a public record.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that
It's
case?
okay.
No.
You get a free pass for a little bit.
So if somebody had been murdered in that case, there might have been a lot less paper, right? Case
Well-
would have been shorter if somebody had gotten murdered, wouldn't it, Miss Bailey?
Yes.
If there wasn't a party, the case would have ended. If that's
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
Exactly, Georgia.
no, because the divorce was over in July. There
Divorce was over in July, but they kept filing papers, didn't they?
Yes.
Well, and the case was set for hearing March 15th. May 15th, 2014. So the motion that Ms. Adamson filed in October, and the motion that Mr. Markel filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markel amped it up again, and on May 5th, he filed the motion that accused Kristen.
So if he was
of
still
fraud.
alive, it would have kept going.
Withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that. How do you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons, couldn't it?
Thank you.
It was set for May 15th and it was
Look what
noticed for
Scott
May
Wolf's
2nd.
going through right now with
But
his
at the
wife.
time of Dan Markel's murder, litigation was still ongoing in this case.
It
Yes? Yes. And even
Sorry,
after that
motion.
was resolved,
This
there
stuff
would be nothing
makes me
stopping them
insane.
from having a bunch of other time sharing issues or whatever come up, and they might have ended up with reams of paper, right?
Objection, Your Honor, calls for speculation.
Overruled, the witness has provided an opinion. The state
Well-
will cross-examine.
I guess my
It's-
response to that would be, I think it would have been to Wendy's benefit to proceed with those hearings because nothing makes someone stop filing nonsense pleadings and motions better than having them ordered to pay the other side's attorney's fees. So had they gone to the hearing on May 15th and had Wendi have been successful, he would have very likely had to pay Wendy's attorney's fees. And I really encourage my clients in these situations to take it to hearing. So once the other side gets kind of slapped down, if you will, by the court and made to pay your fees, then they tend to back off.
But
So
that hadn't happened yet.
it had not happened yet.
And we'll never know when that was going to happen because we never got to that point, right?
Clearly.
Because he was murdered.
Clearly.
May I have a moment to confer, Judge?
Go ahead.
Did she just literally say clearly? That to me is like saying, no shit, bitch. I mean, that's how I took that. That was snarky, lady. Miss Bailey, that was snarky. You did not need to say clearly. That was a Terry comment. Wow. I mean, I think I agree. It's a little bit of a pissing match, but I also think it's been great to show this person is giving an opinion and she is not taking into consideration everyone's emotions are different when it comes to divorce and custody issues. I know people who've gone through custody things and they're like, it's just part of it. And I would have been like, that's not driving you crazy. I would be so furious. Everyone responds different. Oh, yeah, let's zoom in. Let's see if the gills are showing today. See a little bit of gills. And her lines, I forget what those are called, but that is definitely part of her lizard transformation. But yeah, I think the state can let it go now because proven their point. This expert witness is giving testimony about custody issues.
Redirect examination.
Briefly, Your Honor.
Oh, let's see. How does he try to clean this up?
Ms. Bailey, you sat through Kristen Adamson's testimony earlier today, correct?
I did.
Did that in any way influence your testimony here this morning?
No, there was no new information.
Nothing further.
Will this witness be recalled at any point?
Guess he forgot he needed to ask that because she sat in the
Essentially, Your
courtroom.
Honor, but she's free to go about her business.
You remain under your subpoena. Please not discuss your testimony with any other witness in this matter. Have a good day. Members of the jury, at this point, we are going to take our lunch break. Once again, I will instruct you not to discuss your testimony with each
They're all
other
going, thank
or
God.
another person. Do not review or seek out any information outside from this courtroom. We will resume with the trial this afternoon today at 2:20. Please report by 2:15. Enjoy your break.
2:20. So, meditation, I am sorry. There is not. This stream is actually going to end because we didn't set up the portal. We are going to end this. I am going to do midday missing. And then you will come back to Couch Court with Llama stream. Llama will be back, so you will not miss anything this afternoon. But this stream is going to end now. If you all would, please jump over to Midday Missing. Got a couple of really good cases today, and I will see you over there, guys. Bye. you.